May it please your lordship, I beg to mention item number 1920.
Item?
Item number 1920.
This bench does not have item 1920.
May it please the lordship. Lordship, I'd like to mention item number 3 for adjournment. I've already informed the other side.
It's a review matter.
Yeah, it is an RSA. RSA hearing.
You are mentioning it the wrong bench.
For motion, item 1, WBC 1477/2026.
May please look. Also, I file an IA for impeding necessary part in this application. See what you have filed an IA. Lots. 1148/26. What interest do you have to be impeded? Lots of what happened, lots of there was an agreement entered between Ratanpur Estate for supply of green tea leaves. And the value of the contract was about 6 crore and all. But see, when they didn't pay the amount, then we institute title suit before the Court of Civil Justice in Jorat. The suit was decreed in favor of the service applications will have precedence. No, what happened? Yes, this is not a surface. Please to see our decree, Lordship. Page 19, Section B. You see, here what has happened is that the Provident Fund is asking for a priority charge over the assets. And in the meantime, the recovery is sought to be made from the Service Act. The selling of that, not under the Service Act. The bank issued a sale notice that was published in newspaper. After going through that, this is under Service Act. That's why this is the same matter we heard earlier.
Then we come up with receivership.
Yes. This what you call the sale is under the Service Act. So your liability, you have to file a appropriate. No, Lordship, here, Lordship may consider my application. Lordship, what happened thereafter we file exhibition proceeding before the. You see, in this writ petition, you are nobody to be impeded. The reason is, here, please come and see the writ petition. Get a copy of the writ petition. What means here is to forbid from giving effect to the expression of interest issued by the recovery officer, Provident Fund Organization. Yes, Lordship. Correct. Yes, sir. So, in the nature of claim, you are not required to be heard. My Lordship, our claim is that has been decreed in our favor. Thereafter, we file execution. Then attachment order with respect to anything you have to say, you will have to go before the debt recovery appellate tribunal under 19 and then take appropriate remedy. In this writ petition, we can't expand the scope to include your claim. Your claim would be at best a money claim. Yes, Lord. Or enforcement of contract. Yes, Lord. That is correct. In the writ petition, we can't do. Lord, please to see page 35. But particular tea garden has been attached. Please tell us, can we entertain a civil suit in guise of an impeding application? Lordship, then I will be remedial. No, debt recovery tribunal is there. Lordship, particular tea garden has been attached by the land civil competent court. You have to apply there for getting it released. You see, the charge of the Provident Fund is paramount. Yes, greater than the bank. Right. How can we entertain your application? You see, you wanted to buy the green leaves or something. Yes, sir. Then they didn't pay
So we filed a
You can still enforce that agreement. Whoever takes over will be bound by the agreement as
Not
is
what-
various basis.
My claim is staying doesn't take place. Thereafter, let's say I filed execution proceeding that was transferred to Charajo court. Then tea garden was attached lots, like competent execution court. And here we come to know about,
The law gives paramount primacy to the Provident Fund organization.
no, let's say correct, that is, let's say,
So your implementing will not be necessary because here we are not executing any order. They have come that this has to be sold because they say that they have a right. Provident Fund has already issued a sale notice. They have already taken over the property under by engaging a recovery officer.
let's say, the problem is this, the same tea garden has been attached by the landed competent executing court.
But they can't expand the scope.
No, let's
You
say
see,
correct.
let us give, let me give a very horrible example. The PWD did not pay the dues of 10, what you call, 10 contractors. And they have the one vehicle of the chief engineer to be attached. 10 people have attached it. Now, can we, because the 10 people, the degree holders have attached the car, can we join all the execution petitions together?
That is correct, let's say, but here, let's say, probably situation is quite different from. And let's say they issued a sale notice of the particular tea garden. Bank has issued sale notice. After going through that, we can approach this one. Then we can know about the pending of the petition. Page 38 is the sale notice.
You can't thwart, you see, let us assume that we stay everything at your instance. What benefit do you get?
Let's say if the bank sells the property and they get realize the amount, then after satisfying the claim of the
You see, the bank or the provident fund, they are not going to the tea garden, pluck all the leaves so that you don't have any leaves for you.
What's it interestingly, they issued a sale notice of selling of that garden. From that, they proceed, they will adjust their loan and they will pay to the provident fund.
So therefore, whatever is required of you is a pro rata charge. Pro rata charge is, we are not going to entertain that.
Correct, that is,
We have this just recovery tribunal for you.
my immediately, let's say, if the garden is sold, then I will be nowhere. Because they will adjust their amount along with their interest, loan.
And that is of the amount. They are not going to pluck the tea leaves.
No, let's say correct. They are issued sale notice for selling of the tea
I
garden.
don't foresee a manager of the Provident Fund organization going there plucking tree.
No, let's say definitely they are interested in realizing that amount. And
If they sell it, then you'll have to enforce that right, pro rata charge on that.
no, definitely,
Assuming you get it. The dues of Provident Fund is huge.
no, definitely they will get preference over our claim.
And then comes this bank with surface. They
We
will
are
say,
also
they will
having
say,
the
they will
priority
say
of
that it's a new law and therefore that will have primacy.
What's the correct? But the difficulty with the petitioner is this, let's say, if the
That's
tea garden
okay.
is
But
solved.
we are not inclined. Let us see their case first.
Yeah.
Then we'll think over you.
Lots.
Mirror on 20th of March 2026, this was directed us to calculate what amount actually we get, and give it to the bank. But we couldn't because of the elections, Miller. It will also give me 1 week time. We'll come up with the exact calculation, exact figures, so that we can apprise the bank and they can go ahead with the auction. Okay.
Order
Digit 23. Paragraph 6.
For election, you can't calculate.
Because of that, the officials, they were not, this is just 1 week time, we'd come up with the. The calculation, they are doing it, 1 week time, we'll come up with it, exactly.
That makes things very difficult. If you are doing a calculation in the age when we are in computers, then something is wrong.
What happens is, how we calculate, there is a form called Form 1, which we get from the garden. Based on that, we calculate. So just 1 week time, we'll come up with the calculation. That's my humble request. It's on
In the meantime, what is the status of your sale and other things?
Your lordship, sale has been paid. Sale has been paid.
Made,
No bidder turned up.
no bidder turned up. We grant him 1 week's time.
Yes, sir. And we may be allowed to go on auction, but not to finalize it, as given in the last one.
only after we give the calculation.
That
Yes.
will be your second sale notice.
Second segment.
Have you filed a second notice here?
No, not issued. Because without taking the leave of this honorable, your lordship, we cannot.
No card before her. No card before hers. Let me first go and card will follow.
Lots. 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 And Kapati. I am for respondent number 1.
Three, 4, and 5, madam. This is J border 4, 3, 4, and 5. J border.
Much of.
One and two to four.
Your Lordship, my prayer is very small in reference to Rule 9(7). Thereby, I am not denying their charge over the asset.
So before the next settlement, we'll give the.
The only thing left that we have to sell the garden and to give their money on. My point is that they are appointing the receiver, so
There's earlier.
because if the receiver will be appointed, then they will come up there just before your Lordship when this IA has been filed. So they will again come up with this and they will obstruct our sale procedure. No, no, we are not going to stop your Lordship. No, no, no. Earlier, I have an order, your Lordship, in the same manner. He's the authorized officer Hemanta Das, ma'am. Hemanta Das. He is the authorized officer and the senior manager. Yes, sir. Of the assets recovery branch.
So the EPF is, one is the secretary cum commissioner, that is two. Then three is Dinanath, three is the assistant provident fund commissioner. And four is the recovery officer. Yes. So we had come up with the receivership because our dues were not recognized properly. Yes, my lord. That is also, but as you lordship please.
Item 2 for admission.
On last occasion, look, we have already submitted our written submission, that is for clarification. You can.
We make the, what do you call, we reserve the, matter for judgment. This is that case, if you remember correctly, that the victim, there is an allegation that the police officer came and twisted the head and the foot height. And therefore, this is a case of that compensation.
Yes.
We perhaps had drawn the matter because one of us were to be out of station. Sir,
J.H. Roscoe. J.H. Roscoe.
yes, sir. How good is that to be? Judgment is
All good.
For orders, item 3.
May I please? Miss Verma, we need copies of, citations of 2 orders from you. Number 1, that the projected father or mother coming and deposing as witness is not sufficient.
Yes, Lordship.
That, and
That
second
is
is,
oral evidence,
oral
oral
evidence.
evidence, Lordship.
And the merely exhibiting of the voters list is not sufficient.
Yes, we have it, Lordship.
It's 2 in each. I just forgot. Yes, Mr. Das.
My lord. This review petition is filed against my lord in judgment and order dated 15/10/2025, passed by this honorable court. My lord, after passing this judgment and order dated 15/10/25, petitioner had approached before the Honorable Supreme Court with an SLP, and that was disposed of by order dated 6/2/2026 at page 78. Can you find that?
Yes. What are the new documents on which you want to place reliance?
My lord, here I have annexed some documents.
Do you have a copy of the SLP with you?
SL copy also. That copy is not. But I can produce it on next date, my lord. Copy of video upload.
What are the new documents on which you intend to rely?
Page 80 to 81, that is fine.
Page?
Page 80, 80. Here I have annexed some documents revealed so that the server report already here, server report, it is showing that in vernacular, vernacular to VPN, that could be the vernacular to VPN. That could be the Here, my lord, in vernacular, page 81, I have type copy is not given here. That petitioner had denied to accept the notice. But somehow the process server man had got some impression on this notice of Amiruddin. But here it is, son is Nur Islam, but my father's name is Nur Islam, but my father's name is Lalu Miah. So there is a basic difference in my lord regarding my father's name. And that was so to say, my lord, notice was not served upon me. Somebody else, that is Amiruddin, not me, my lord. 87, my lord. Original is there, my lord. I can produce it as well. My lord, that original copy I will produce my next book, my lord. Original. My lord, here it is my fault. I will annex type of my lord, because it was filed in hurry, my lord, since time limitation was granted by Honorable Supreme Court. I will produce my type of all this. Here, handwriting is there, so it is very difficult to read, my lord. I will produce. That's property. After 2 weeks, I have to produce my original copies. Or it is, my lord, as per convenience of this honorable court, my lord. Yes, ma'am. Publish.
For orders, item 4.
Lordship, before my friend begins, I think this is defective the grounds. The certificate is not attached, Lordship. Page 8A, page 8A. Here, moving some of the corrected copy. No, actually, five is the certificate, not this. After that, it is. In my copy, it's not there, Lordship. She is stating at page 8A, there is a certificate, but the copy served to us does not have it, Lordship. Review, Lordship. Yeah, basically, okay, review. The advocate certificate, Lordship. Your Lordship, what happened, we served the copy, after that we filed the review petition, then the objection came up. Yes, so that thing is that we didn't provide that. Yes, Lordship. See that.
For a date to be prepared. You're not giving a fixed date because the division bench, is given to. Also the day you give that certificate.
Thank you.
Please, Your Lordship, I'm praying on behalf for the item number 19820. My lord, I'm praying on behalf of the appellant. One side has other side has also been taken by them.
Can it come after, my lord, the summer vacation? It's a new case, my lord, 25.
1920,
19 and 20, my lord,
which says it presented.
out of the same judge.
The prayer made by Mr. N. Das and counsel for the appellant. Matters as adjourned today, please. After the ensuing summer vacation.
File your.
With the Lordship. Lordship, yesterday one matter was listed for order 41 rule 11 hearing. Lordship, my junior made a mention that in this case we have filed a substitution and confirmation. So your Lordship directed to list this matter on Friday, Lordship. There is an execution petition is going on. In this case, what happened, Lordship? The RSA was filed in the year 2022. Thereafter, the engaged counsel died. So the file is under objection, Lordship, and then by that time, respondent number 1 died. So I have filed one amendment application for impleading the legal errors. They were already impleaded in the execution proceeding, along with the condonation application and one additional affidavit bringing on record the present status of the executing court. So matter, if your Lordship take up this matter, order 41 or in order column tomorrow, Lordship. Tomorrow they will come to the suit lane to evict the appellant. And 22, there is an order for report of the
It should be better, you know.
obliged.
May I be your lordship with the consent of other matter. I get question item number 8, madam.
8,
Lordship. In this case, my lord, appellant, yesterday has been engaged new set of counsel, my lord. This matter,
we can't adjourn for that. It's a 2016 matter.
lordship.
If they've engaged somebody else, the other side should be prepared and come and argue the matter.
After 2 weeks, my lord.
No. If they have disengaged you, then you can't make a prayer.
So, my lord, earlier, Mr. Banerjee, appeared, my lord.
That's okay.
That is fine, my lord.
Item number 8.
Lordship.
No, let the new council appear if they have taken over the brief. You inform them that we got adjourned. Then after
For Lordship, this 2016 RSA matter, last time listed in on 2017 matter. That's been listed for a hearing matter.
this will all come. If it is 2020, this matters will start coming.
2016 matter.
Till
That-
2020, it will start coming.
Or for orders matter. Then so that it can be fixed for hearing.
It will come for hearing.
My
If these matters are ready for hearing, it will come in due course, because every day we can't take up 20, 30 seconds for hearing.
2017, it was posted for hearing, my lord.
That's okay. You see, we have our limitations.
My,
If there are 20 cases for hearing, we can't take up second appeal to 20 cases.
No.
It will come, don't worry.
my, public.
It will come in due course.
May I please, lord?
Due course means, within 10 to, immediately after the vacations, it will be listed. All those matters which are left out till 2020.
My, public.
May I please, lord? My lord, with the consent of other parties, I beg to mention item number 17. My senior-
17.
Yes, ma'am. My senior won't be able to attend and this is.
Case, I have got the respondent, Lordship.
17 after vacation.
Lordship,
17.
if possible, on 2nd of June, Lordship, today they have some difficulty, Lordship.
2nd of June,
Yes, Lordship.
in special bench? No, not on 2nd. Listed on 3rd. P6. 2nd, we have a special bench.
See, this is a hearing matter, Lordship, so
It
can it
doesn't
be a
matter.
first day, Lordship?
It doesn't matter.
Obliged.
Item number 17. Both sides are present.
Please, your lordship. With the consent of other side, I'd like to mention item number 3, your lordship.
Item number
3, your lordship. Lordship, here we need to reconstruct our file.
See, can't be adjourned, 2010 matter.
Lordship, we don't have the file here, so we need to reconstitute the file, Your Lordship. For a week, Your Lordship. You have applied for the certified copies also.
2010 we can't adjourn, you could have applied earlier.
Lordship, we have applied, but we have only got the memo. We don't have the exhibit or nothing else.
Let us call the matter first, then we'll decide.
Lordship.
May it please your lordship, item number 15, lordship, this has been wrongly listed in the hearing column. There is one IE which has been listed and there is another IE, lordship. We have filed two IEs for substitution and imprisonment. It should have been listed in the orders column, lordship.
What is this IA for?
Lordship, for substitution and imprisonment.
We'll take it up, don't worry.
Lordship. Lordship, there's another prayer for listing of a CRP in the orders column next week, any date, lordship.
You give it to the court master.
I beg to mention for ICV, or in RSA. For the matter has been compromised between the parties. So we have a joint petition for disposal of the matter.
Give it to the court.
For orders, item 1, RSA 41/2020.
Yeah, please, your lordship. Lord, as per office note, my lord, have this available. We have taken a step, my lord. Upon the
You did not take steps. 3A, you have not taken
3A, my lord,
steps.
in the meantime, 3A expired, my lord. And the legal heir of 3A are already party, my lord. So the name of 3A may be staggered.
In your name,
A. Rashid.
A. Rashid, learned counsel for the petitioner, submits that in the meantime, the respondent number 3A has expired and his legal representatives are only on record. Accordingly, on his prayer made, the name of respondent number 3A shall transfer with the risk of the appellant. Next para. The experts revealed that notice on respondent numbers 1, 2, 3B to 3E, 4 and 5 was issued by registered post with AD on 29/1/2025. Until date, service is awaited. So accordingly, the applicant shall take steps within 2 days for service of notice on the respondent numbers 1, 2, 3B, 3C, 3D, 3E, 4 and 5. By speed post with AD, of the learned counsel for the appellant is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next, in addition, the petitioner the appellant shall also take steps for service of notice on the said respondents by usual process to be served to the jurisdictional civil court. The judge in charge of the Nazir branch the district judiciary in Nagaon shall So that the on receipt of steps, the Nazir branch of the district judiciary at Nagaon shall ensure that after service, the service report is returned to the court prior to the next date of listing. Next, permitting service of notice list on date after 6 weeks. Steps within 2 days. By both ways. Your lordship. Next, item 2.
Item 2.
May I please, your lordship?
Will it be present?
Yes. Your suit was dismissed.
My lord, present appellant was the plaintiff. His suit was dismissed and in appeal it was affirmed the concurrent findings of. Now, plaintiff's suit was for declaration of right title interest and recovery of possessions. He stated that he purchased this suit land.
But the second appeal was admitted on the question of law.
Yes. That is,
That
my lord,
said it is a public document, it is
public
not.
document or not,
It is a private document in public custody.
my lord. But that is to be satisfied.
If
my
that
lord-
is so, then it is not admissible under section 65.
65, that is the, my lord, issue in this case. My lord. Now, question is that whether certified copy of the sale deed is a public document or not.
No, it is not.
No.
It's a private document in public record.
That is the issue, my lord. Now, my question is in 2023, Supreme Court has said that it is a public document. I may read. If it is a private document, my lord, I have no case. From paragraph 19.
Nineteen,
A paragraph from starts on 19, my lord,
which is the 11th paragraph.
and 11, 29. Possibly 29 will help.
29.
29. May I read it? Yes, my lord. So certified copy of the it is, my lord, here it is stated that is held. That is a public document. And
Was that document produced before the trial court?
my lord,
You see, the finding of the trial court is at page 16 on this production of the document. Please come to page 16, second last paragraph. For this purpose, I am taking into account section 65 of the Indian Evidence Act.
60. It is because it is secondary evidence. That is why 65. Now, Supreme Court held that no certified copy of a CLD is a public document.
Yes,
So-
but the original is there, 65 has to be complied with.
65 for certified copy. 65E, if 65E is
Certified copy, but 65 requires that the original could not be produced. In your case, there is no document to show that in the sub-registrar office that was lost, missing.
yes.
It's not there. And this paragraph, page 16, second last paragraph, it says that you
It is-
never called for never took into custody
was-
the original
It
record.
was with the register office. That is
The
the
sub-registrar
register
office.
office. And that is why also I have filed a petition out of 41
Because
rupees.
you see, the judgment which you are citing,
My,
please come to paragraph 30.
my lord. Here also, my lord, they have not disputed this CLD. In my case also. They have only stated it is a forged one, but that issue was also framed and that issue was gone against him, against the defendant. So for execution of that deed, there is no any dispute. They have not disputed the execution of that.
Yes, Mr. Goswami, there is no objection in this cross-examination of PW1 on this sale deed, my lord. Mr. Hawk is referring to this judgment. That if there is no objection, then the sale deed would be admissible. Take it.
But the vendor has denied that there was any execution of the sale deed.
Vendor came as witness. Witness came as witness.
Yes.
As a defendant, actually, he came as witness. I think he is
DW4.
PW4,
DW4.
DW4.
Order, my lord, I am appealing for the older respondents. Now I have no any relation with this, my lord, out of about 7 or 8 respondents, my lord. Whether they are, my lord, dear or not. I don't have any, my lord.
So we understand, but on the part, the PW1 was never cross-examined on this.
Yes.
Because their case is that it was forced.
They could have, my lord, filed this petition for evidence, my lord, at the appellate stage also. Long back, say in 2009, this judgment, title appeal was heard and decided, my lord. If the same was there, my lord, they could have filed here. A long back, my lord,
This
about
Moxit
15
Ali-
years.
Just a moment. Moxit Ali was not examined. Moxit Ali was not examined. He's the vendor.
As a DW.
He was your vendor, Moxit Ali.
Yes.
DW1 is Abdul Majid. DW2 is Yusuf Ali. DW3 Muhammad Moxit. He came as DW.
He denied the execution, of course.
Hmm?
He denied the execution of the sale.
He denied. Then, if he has denied, then how can you sustain that?
It is,
Even with this judgment, how can you sustain that?
now, that question, my lord, that is,
Because he did not come as your witness.
no.
He came as DW and denied it.
Witness to the, my lord, sale deed. He was at ground.
If he is present, then the attesting witness will only be either a supporting or a witness to controversy. If the vendor himself says no, then how do you sustain that? Because then there's a reason to disagree with that judgment of the Supreme Court. There is a reason. Not to accept this in this case. মোকো পাঠাও ডাগৰ কোনো জমি মই বাদীৰ ওচৰত বিক্ৰী কৰা নাই।
Denied.
বাদীয়ে একে গাঁৱৰ কাজিমুদ্দিনৰ ওচৰত মই বন্ধক বন্ধক সূত্ৰে জালিয়াতি কৰি বিক্ৰী দলিল সম্পাদন কৰা হৈছিল। In this cross-examination, he has done more damage. He has denied that he has executed the sale deed or given you the possession.
I purchased 1 bighah of land, out of 1 bighah, my lord, half bighah of land, my lord.
Yeah, three times this was asked and he has denied that I have
Yes,
sold any land to it.
execution denied. Now, question is the matter of whether this documentary evidence will prevail over that, my lord.
Yes, because if the vendor denies, then you have to send the thumb impression for forensic examination. That was not done.
But they have not disputed that, my lord, sale deed.
They have disputed it now by coming as witness.
And the issue was also framed that it is a forged one. But that is, that has gone against the defendant. So, but deed is concerned when deed is correct. If deed is correct, my his oral evidence will, my lord,
No, you see, the
madam.
you are the plaintiff.
That is
Whether it will be more on
burden, course, that is. That only on his statement, my lord, my sale deed will go. Only statement of that, my lord, my sale deed will go. Because if they are objecting or, then they have to prove, they have to challenge this also, my sale deed. But defendant has not challenged.
No. He says that he has not told it. This is challenging. Or you came to court seeking a declaration. If that declaration fails, he does not have to challenge it.
No, that is, but he is only on the basis of that oral evidence of pro forma defendant.
No, but
Even he has not,
this was not appropriately handled.
and on the other hand, we have filed also, my lord, order 41 Rule 27 petition also,
Yeah,
here also.
that will not be allowed.
Yes, that is up to your lordship, but question is that whether it can be allowed or it should be given.
After the law being settled on how and at what time Order 41 Rule 27 can be entertained.
For proper and just decisions, it can be, my lord, it is the 22 decision. In 22 decision, my lord. Your lordship, yesterday also, my lord, deal with that order 47 rule.
Who was that?
For just and proper decision, your lordships can look into this. Only because of my vendor has said, and the deed was not disputed by the defendants also.
Evidence was originally against you. What is the decision you are citing?
Yes, that. 2022-7 execution, 347. There are 7.
Subject person.
Yes,
Yesterday this was cited.
yesterday your lordship guilty.
You just take a short break and come back. I'll just take a short break and come back.
Page number to Kiran, bola.
Sorry, Mr. Hawk, it will be a negative against you.
My submission is the oral, on the basis of that oral evidence, my sale deed will go, whether it is. And it is not, my lord, in defendant's case, it was not disputed also. That is my submission.
No, you have a reasonable ground to urge here because he was a pro forma defendant.
Yes,
He did not file his written statement. And therefore the evidence is beyond trading.
yes.
That favors you. But ultimately, it turns out to be negative because he has disputed his the sale. And he has denied that he has not done the sale.
Yes.
And in that, during that time, forensic examination ought to have been done. That was not done because the original schedule was never produced, and even at that stage, it was not followed.
Forensic could not be done because the original was not before.
It's okay, but
Before.
had the lawyer been alive to the issue, he would have definitely got it.
That is,
So
then it was in the sub-register office that could have been brought. That was not done.
he, at that point of time, he failed.
He at that point of time. So at this
So
point,
now the second issue would be if that prayer for order additional evidence was not taken in the first appellate court, whether it is permissible for this court in second appeal.
possibly in second appeal also it can be. Because
No, because you see, the problem is this question of law which is framed.
It's almost about 15 years have passed.
Whether certified copy of sale deed is a public document within the meaning of section 74. And if so, whether the same is admissible under section 65 of the act, that is the issue.
question of that is to be decided, my lord. Other aspect, my lord, all of the question of fact. Others, all a question of fact. This issue may be decided. But if it is not a public document, when I have no case. It is not a public document, I have no case.
You 74 is attracted, because 74, I think D would be covered, public document in, private document in public record. So that is there. Even this judgment says that the same can be relied.
Yes.
But when the signature is, when this execution is denied, then can a certified copy partake a character of the primary evidence?
But if it is not the case, their case,
If it's there.
it is not their case.
It is their, my lord, responsibility to prove that. They will not produce their certified
No,
copy only.
he could have proved it. The problem is that he was not in the good hands. That is the sad part. He was not in good hands. Otherwise, you also know the fate.
Yes.
That is.
When the executor PW4 has denied execution, my lord, nothing, my lord.
No, even
The concurrent finding.
that could have been tackled. That could have been tackled.
At that time.
There is also
At that
timing.
time. We told you one question in the cross-examination, have you filed your written statement? No. Is this stand which you are now taking is on record? It says no. Therefore, knowing his notice is served, he knows that the document is there. He doesn't challenge it as fraud.
Yes.
He can't take a plea in the evidence that is contrary to the pleadings.
At this stage, my lord, that original, even if it is produced, cannot be proved, my lord.
Third, Mr. N. Hoffman, counsel for the petitioner, as well as Mr. R. Goswami, counsel for the respondent. By filing this appeal under section 100 of the CPC, the appellant has assailed the judgment dated judgment or order dated 18/5/2009. Passed by the learned civil judge from Borpeta in title appeal number 12 of 2008. And consequential decree by which the said appeal was dismissed and the judgment and decree dated 24/3/2008 passed by the learned Munsif from Bajoli Kaur Pathshala in TS number 1 of 2007 was affirmed. Next, in brief, the case of the petitioner is that appellant is that he had filed a suit against the respondents for declaration of right, title, and interest, recovery of past possession by evicting the respondents from the suit land described in Schedule B out of land described in Schedule A of the plaint, and for removal of the house described in Schedule C of the plaint, and for permanent injunction. The said suit was registered as title suit number 1 of 2007 and of 7. That's right. Next part, continue to send the check this. It may be stated that in the plaint, apart from the 8 respondents as dependents, the 2 pro forma dependents. The defendant numbers 1, 2, and 3 contested the suit by filing their written statement denying execution of the sale deed and asserting their possession of the suit land. And giving the sale deed to be forged. In course of trial, the learned trial court had framed 9 issues, page 15. Pencil, blue pencil. In support of the claim, the petitioner examined 4 witnesses and exhibited 5 documents. Being certified copy of registered sale deed number 2689/05 within bracket exhibit 1, original land revenue payment receipt for the year 2000-2001 or 2004-2005, 2005-2006 within bracket exhibit numbers 2, 3, and 4 bracket close, and certified copy of January within bracket exhibit 5. The contesting respondents had also examined 4 witnesses and had exhibited the certified copy of Jawabandi within bracket exhibit called K, certified copy of Kita within bracket exhibit called original registered sale deed number 3087 of 75 dated 25/11/1975 within bracket exhibit 4. In respect of issue number 2, the trial court, on the basis of evidence on record, according to finding that in the pleadings, the sale deed number is the number of the certified copy of the sale deed is 2689 of 05. As per pleadings in the first paragraph, comma, it is claimed that the scheduled suit land was brought from the pro forma defendant Mokshed, MOKSHED, Ali, by registered sale deed number 2659 of 05. In the evidence on affidavit of PW1, comma, the petitioner had stated that the number of registered sale deed as 2659 of 05. Whereas PW2 referred the said sale deed as deed number 2351 of 05. PW2 and PW3, sorry, no, PW2. PW3 has referred the said registered sale deed number as 2359 of 05. As per the evidence of Abid Ali, PW4, the original sale deed was with the office of the sub-registrar proprietor. However, the vendor, Mokshed Ali, or the proper defendant number two. It as BW3 and denied having sold any land to the appellant. And according to him, he was the owner of only 2 kata 10 acres of land in Act number 299. The learned trial court also recorded that BW2 and BW3 could not say where the sale deed was registered. Accordingly, taking into account the provision of section 65 of the Evidence Act of 1872, of which provides that secondary evidence of a document can be given when original is in possession of the adverse party. Accordingly, as the appellants did not pay for calling the said document from the sub-registrar office. Issue number 2 was decided in negative against the appellant. In respect of issue number 1, it is right that the interest of the appellant over the suit land. As the appellant had failed to produce the original sale deed of 1 bigger land. The issue was decided in the negative. And against the appellant. Issue number 3 relating whether the registered sale deed number 2659 of the 05 is a false one. The learned trial court held that the defendants, respondents defendants had failed to prove forgery, and therefore the issue was decided in the negative and against the respondents. In respect of issue number 4, which relates to dispossession of the plaintiff, petitioner, plaintiff, appellant plaintiff. Learned Talbot by referring to the evidence of PW 1, 2, and 3 held that the plaintiff's witnesses had admitted that they had no idea what was written in the evidence on affidavit. And as it has not been stated that under what circumstances and events the disposition took place, or the issue was decided against the appellants, as you got issue number 5 relating to cause of action. It was the learned Talbot had held that the appellants had failed to prove the case against the defendants in view of the issue number 1, 2, 3, and 4. Discussed by the learned trial court in respect of issue number 6. Though the suit was valued at rupees 5,000, but in view of the evidence of the petitioner that the suit land is valued at rupees 12,500, it was held that the ad valorem court fee would be rupees 957.85, and therefore the appellant was required to pay an additional court fee of rupees 495. Accordingly, issue number 6 was decided against the appellant. Issue number 7 relating to non-general necessary parties was decided against the defendants, the respondents' defendants. In respect of issue number 8, it was held that the suit is not barred by limitation, and accordingly, the issue was decided in favor of the appellant. In respect of issue number 9, appellant plaintiff was not found entitled to any relief. Next. The first admitted court by the impugned judgment decree, constitutional decree dated 18/5/2009, affirmed the decision of the learned first appellate court. Found no scope of interference with the decision of the learned trial court, and accordingly the appeal was dismissed. As no infirmity was found in respect of the judgment and decree passed by the Government Trial Court, there's no reason to burden this order with the discussion of the first appellate court. Next part. The instant appeal was admitted for hearing on the following substantial question of law by order dated 31/5/2010. Right. Next part. In support of the appeal and to submit in support of the substantial question of law on which this appeal was admitted for hearing. The learned, just give that citation. Suppose that citation should be open. Learned, counsel for the appellant has cited the case of Andi Muthu, ANDIMUTHU, alias Thangapandi, THANGAPANDI, and others. Oh, sorry, APPAIYA versus Andi Muthu alias Thangapandi and another, comma, AIR 2023 SC 4810 equal to within bracket 2023 bracket close 0 Supreme SC 974. And it submitted that the said decision is an authority on the point that once a document is registered under the Registration Act, comma, there is permissibility for production of certified copy against the evidence in law. In regard to the existence, comma, condition or contents of a document, and accordingly, it was held that certified copy of sale deed is admissible in evidence for purpose of proving the contents of the original documents. In light of the said decision, the issue relating to the non-production of the original sale deed has been examined. Next one, the defendant numbers, the respondent, defendant numbers 1, 2, and 3. In their written statement, had not admitted the execution of the sale deed by the performer respondent number 2. Rather, it was stated by giving a general denial, it was stated that the same was false and the respondent plaintiff was, the appellant plaintiff was found to prove it by using evidence. And later on, it was stated that the appellate plaintiff may have registered in his name, but no actual survey by the revenue staff and no formal delivery position was handed over to the by the seller at any point of time. And it was alleged that the appellant plaintiff was trying to get degree by giving false statement on the basis of forged registered sale deed. In the proceeding before the learned trial court, no effort was made to break the original registered sale deed on record. As already indicated above, while deciding the issue number 2, the learned trial court found variance in the registered sale deed number. In the certified copy of sale deed, the number of the deed is 2689 of 05. And in paragraph 1 of the claim, the number of the sale deed was mentioned as deed number 2659 of 05. While PW1, appellant PW1 has given the number of sale deed as 2659 of 05 in its evidence on affidavit. According to PW2, the number of the sale deed at paragraph ID of the evidence on affidavit PW2 is 2351 of 05. And PW3 in paragraph 3 of the evidence on affidavit has referred to the sale deed numbered as 2359 of 05. Under such circumstances, when there's a variance between the pleadings and the evidence tendered by the witnesses, cannot be said that without proving the original sale deed. Certified copy would be a good evidence. There is no quarrel with the decision of the Supreme Court of India in the case of APPAIA, then bracket Supra. However, it said decision must be held to be review expressed under the facts and circumstances of the said case. Full stop. Next up. In the case of APPAIA, the judgment in the original judgment in OS number 104 of 96 was passed on 30/9/1997. the appellate judgment in AS number 65 of 67 was passed by P7/2001. And the second appellate judgment by the High Court was passed on 17/10/2012 in second appeal within bracket MD bracket was number 802 of 2004. Therefore, when the judgment of the learned trial court, the judgment decree of the learned trial court and the first appeal court was passed, the same was on the basis of the provisions of Order 18 as it stood before its amendment by way of substitution by Code of Civil Procedure within bracket amendment bracket was Act 1999 with effect from 1/7/2002. Full stop. After the amendment of these provisions of after amendment of the provisions of the CPC, Order 18 Rule 4 was substituted, and the after the amendment, the amended therefore, the provision of two that accordingly, the court is accordingly for comparative study, the provision of Order 18 Rule 4 as it stood earlier prior to amendment, and the provision of Order 18 Rule 4 as it stood after amendment are quoted below. Next paragraph. After the amendment to the provision of Order 18 Rule 4 CPC, under proviso J2, it is provided that where documents are filed and the parties rely on the documents, the proof and admissibility of such documents which are filed along with the affidavit shall be subject to the orders of the court. Therefore, when there is admitted discrepancy in the when there is a discrepancy in the pleadings and proof of the sale deed number, and when the and when the DW3, who is the vendor of the sale deed, comes and disputes execution of the sale deed, and confirms that he has not executed any sale deed, and such evidence could not be demolished during cross-examination, and the sale deed was not sent for forensic examination of the signatures, comma, in the opinion of the considered opinion of the court, comma, reliance on a certified copy of the sale deed would be impermissible, as the vendor has denied his signature, denied execution of the sale deed. Therefore, come on facts, the case presented in the present case is distinguishable from the facts of the case in Anandi Puttu, as well as on the change of law under which the said judgment was passed. So please make clear that there is no quarrel with the proposition that the sale deed would be covered by the provision of section 74 relating to public documents in respect of the sale deed, which is covered by section 74 within bracket 2, comma, being public records kept in the state of Assam of private documents. Next. In course of this appeal, comma, the appellant has filed IA Civil 273 of 2025 and Order 41, Rule 27 of the Civil Procedure Code for production of additional evidence at the stage of second appeal. The new route and the old route. You can sit on the last. Filed an interlocutory application under Order 41 Rule 27 for producing additional evidence at the stage, second appellate stage. But it is projected that as a layman, the General Counsel for the appellant has submitted that as a layman, the appellant would not have known the legal provision as to how a sale deed is to be proved. It is stated that the certified copy of the sale deed had registration number 2689 of the 05. And as the appellant was an illiterate person, he had no knowledge of discrepancies in the sale deed number in the pleadings and the evidence of the witnesses. It was submitted that the appellants were not aware of the provisions of Order 41, Rule 27, CPC that could have been applied in the first appellate stage. And it is only at this stage that the appellants came to know about the provision of Order 41, Rule 41, Rule 27 to produce original sale deed at the appellate stage. The learned counsel for the appellant had submitted that the said document is vital to decide the substantial question of law involved in this appeal. The learned counsel for the respondent opposed the prayer. Any submission in support of his submissions, the learned counsel for the appellant has cited the case of Sanjay Kumar Singh versus State of Jharkhand, 2022, within bracket 7 SCC 247. In this regard, in the considered opinion of the court, the law relating to additional evidence has been well settled in the decision of the Supreme Court of India in the case of Union of India versus Ibrahimuddin and another within bracket 2012, bracket 8 SCC 148, equivalent to 2012 within bracket 0 Supreme within bracket SC 465. As per the said decision, if evidence is available on record, sufficient for the judgment, or the provision of Order 41, Rule 27 cannot be resorted to, and there must exist sufficient cause for invoking the said provision. It has also been held that if the appellate court requires additional evidence, when evidence taken by the trial and first appellate court is so imperfect that a satisfactory judgment cannot be passed on that basis, only then Order 41, Rule 27 can be resorted to. So in this case, of this concurrent finding of fact of dismissal of the suit on account of non-exhibiting of the original sale deed. So therefore, it cannot be said that that the second appellate court cannot hear and dispose of the appeal on the basis of the evidence already on record. So this is not a case where there exists a doubt in the mind of the court, and the additional evidence sought to be adduced would remove the cloud of doubt over the case. There can be a view in this case that as the suit and the first appeal was decided against the appellate by an additional evidence, the lacuna which remained in the trial court would be filled up. It is not the case of the appellant that any prayer was made before the trial court to call for the original sale deed. Trial court as well as first appellate court could call for the sale deed. Therefore, and no prayer for calling of the original sale deed was made. No steps was also taken to have the original document exhibited. Therefore, the this is not found to be a fit and proper case to entertain and allow the application. File an order 41, Rule 27, CBC, registered as IA 273 of 2025. Accordingly, separate order is being passed in this interlocutory application. Next one. Resultantly, the substantial question of law is in view of the provision of order 18 Rule 4 as amended. Though the certified copy of the sale deed is a public document within the meaning of section 74 within bracket 2 of the Evidence Act, as there is a variance between pleading and evidence with regard to the sale deed number as referred above, in this case, in the facts unique to this case, the certified copy of the sale deed will not be admissible under section 6, without compliance of section 65 of the Evidence Act. As the executor of the sale deed was examined as DW3, namely Maqsad Ali, had denied executing the said sale deed, and his evidence could not be demolished during cross-examination. So thus, in this case, not only the registration, but also the execution of the sale deed was required to be proved. Accordingly, the substantial question of law is decided against the appellant, resultantly, the appeal fails on the same is expressed. Next, the registry shall send back the records of the transport and the first appellate to go.
Okay.
Item 4 for hearing.
Item 3, they are searching out the record, somehow misplaced. Pending.
Yes,
Yes.
yes, my lord. My lord, this RSA regular second appeal is, there are several substantial question of law formulated, my lord. And this second appeal is arise against the judgment and order and decree passed by the learned trial court and first appellate court, my lord. My lord, in this, the background of this case is that one Azizur Rahman, he is the vendor of the suit land, my lord, and he first time he didn't agree, he executed an agreement for sale to the defendant appellant, my lord, first time. That is on 14/7/1995. And at the time of the execution of the agreement for sale of the suit land, the land was
The
not,
date of agreement for sale,
yes, my lord.
what is the date of agreement of sale?
Date of our agreement of sale was 14/7/1995. Yeah. Hereafter, hereafter, then he got periodic patta, my lord, under Azizur Rahman Chaudhuri. He got periodic patta. Then after getting the periodic patta, he executed a registered deed to the respondent plaintiff, my lord. And that is in the year 1996, my lord.
It is dated,
Yes, registered deed dated, my lord, for the registered deed dated 13/11/96, my lord.
something is wrong as per the plaintiff, it is.
14/5/96.
Yes. Then, my lord, after execution of the,
What is right? 1196 or 14596?
Yes, yes, my lord, I am going through the record, my lord.
As per the record, the sale deed number is 514 of 96.
That's correct.
Item 3.
Lordship.
Three.
Like that, what you were asking. See the last part, that's why. Yes, your lordship. March that you reconstruct the file.
Lordship, we have actually tried to reconstruct the file, but instead of all the exhibits and all, we have just got the RSA appeal, your lordship. And
That we don't know.
Lordship,
2010 matters.
yes, your lordship. So there is one more issue, lordship.
Examples on top of the head.
Lordship, what I'm praying is, there is one more issue. My senior, Mr. K.K. Mohanto, is having cataract issue. He'll be having a surgery next week, this Friday, your lordship. So my lord,
2 weeks then.
2 weeks.
Can't give a long example.
Lordship, lordship.
Is it- I don't think. Is it- Take it out of the. Okay, fill in. Captain Sudhir. Next week. Paper, This we got full printing cover. This is the data. Yes.
Yes, I'm going to the, my lord. My lord, I am going that, the background of the case, my lord, the suit of title suit, my lord. First, the vendor, one vendor, he sold this disputed land, suit land 2 times, my lord. First time, agreement for sale in consideration of rupees 24,000 to the defendant. That is the present appellant, the legal years of the present appellant, my lord. And this agreement for sale was executed on 14/5/1995. It is in page number 61. And in document number 1, exhibit co, my lord. And after execution of this agreement for sale, my lord, possession of the suit land handed over to the defendant, my lord, defendant appellant, taking 24,000 in cash, my lord, and vendor promised to execute the registered deed to the defendant appellant within 3 months, just after getting Miadi Patta, my lord. Otherwise, and it is stated in the agreement that otherwise he will be punishable as per law. This is the contents of the agreement, my lord. This is as a document number 1, exhibit co, my lord. My lord, hereafter, as per order 22/11/1995, Kamalpur officer, Circle Officer Kamalpur, mutation was done in the name of Azizur Rahman Chaudhuri, that is vendor, to purchase minor. In the year 1995, 22/11/1995, mutation was done in favor of the vendor minor, Azizur Rahman Chaudhuri. And after getting his periodic patra, his vendor minor executed second sale deed my lord, that is, it is registered deed my lord, in favor of the plaintiff respondent my lord. That is on 14/5/1996. That is, instead of betrayed the defendant appellant, and he taking rupees 30,000, he executed sale deed, registered deed in favor of the plaintiff respondent. And just after 11 days, mutation was done in favor of the plaintiff respondent. After 11 days of his vendor, mutation is done in favor of the plaintiff respondent, my lord. And at the time of the execution of the Vainapatra, sale for the agreement for sale, taking 24,000 rupees from the defendant appellant, defendant was handed over the possession of the suit land, my lord. And after taking the possession, he started paddy cultivation on the suit land, my lord. And just after execution of the registered deed in favor of the plaintiff respondent, dispute occurred regarding possession of the land, and having no alternative, the defendant appellant approached to the executive magistrate, and executive magistrate, on the basis of the agreement for sale, that is the document number 1, draw up the proceeding under section 145 and attach the disputed land under section 145(6), my lord, and directed both the parties not to enter in the suit land. And the first dispute occurred just after registration of the sale deed in favor of the plaintiff.
Think wrong, your presentation of facts. From the appellate order at page, order, paragraph 15, appears that the agreement for sale with you was the wife of the appellant.
Yes, my lord, wife of the appellant, my lord. Wife of the, this is
Wife
what,
was never the recorded owner of the land. The facts do not match.
defend now is the wife is the legal heir, my lord.
You can there is something else, but the agreement was made by the wife.
Yes, my lord.
There's nothing on record to show that at that time, this was embargo debt. You have no counterclaim regarding either your purchase or your possession. And the sale which was made is a perfect sale.
My lord, in the written statement, it is also stated that the,
You see, this question of law is whether the suit is barred by limitation review, Article 58. If the agreement of sale is 1995 and sale deed is 1996 based on title, why is it for position to be barred under 58?
At the time after,
It is based on title.
yes,
Then
my lord, after hearing of the first hearing, preliminary hearing, honorable predecessor judge, my lord, honorable court of this honorable court has has passed the order. It is, your lordship kindly see the order passed by the,
which order?
my lord, it is passed on in the year 2022, before 21/9/2012, my lord. Long order, my lord.
Well, two issues were there. The first question of our two,
Yes, my lord.
whether it is backed by limitation in view of Article 58.
Yes, my lord.
The second is whether by not affording obstacle to or dispute the additional issue
Yes, my lord.
as framed during the writing of the judgment.
Yes, my
The
lord.
trial court has committed illegality. Well, the two issues. It's a question of law. First, substantive question of law.
I am going through the order of the, my lord. This is an appeal under section 100 of the Code of Civil Procedure against judgment and decree 15/6/2010 passed by the title appeal 13/208 by the civil judge, senior division number 2, Kamrup, Gauhati. It appears from the pleaded case in the plain that the cause of action for the suit arose on 20/11/1996 for the first time. The date on which the executive magistrate attached the suitland, and subsequently on 29/11/1999, the date on which the final order was passed by the executive magistrate Romia in case number 128 M of 1996. It also appears from the judgment and decree passed by the trial court dated 9/4/2028 as passed in title suit number 855 of 2006, corresponding TS number
It is not
20.
necessary. The first question of law is there. Why should all this coming our way?
In your lordship, in view of the submission advanced by the learned counsel of the appellant, admit this appeal on the following substantial question of law: whether the suit is barred by the limitation in view of the provision of Article 58 of the Limitation Act 1963 on the basis of the pleaded cause of action by the plaintiff. Number two, whether by not affording opportunity to prove or disprove the additional issue as framed during the writing of the judgment, the trial court has committed illegality. My lord, before I'm going through the first, whether the suit is barred by the Limitation Act under Article 58. My lord, in the written statement in page number 53, my lord, WS, it was contended that the suit is not maintainable in law and fact and circumstances of the case. And in the written argument also, it was pleaded by the appellant defendant that the suit is barred under the provision of law under Section 5 of the Limitation Act. My lord, while delivering judgment by the trial court passing the decree, my lord, your lordship kindly peruse the judgment and order dated in page number 34, my lord. Page number 34, my lord. Yes. Now I am deciding issue number 2 of this suit.
issue number 2, 5 and 3 of the Limitation Act cast a duty upon the court to decide the question of limitation even if the plea is not raised by the parties. The learned counsel of the defendant in his written argument stated that suit is barred by limitation as the alleged sale deed was executed by Azizur Rahman Chaudhuri in the year 1996. So a declaratory suit has to be filed within 3 years in the year 1999. But the suit was filed in the year 2000. As such, the suit is barred by limitation. Par contra, the learned counsel of the plaintiff, Mr. Partha Chaudhuri, in his written argument, submitted that the suit is not barred by limitation as the plaintiff in his pleadings as well as in evidence has stated that he is possessing the suit land, but his rights, title, interest, and possession was threatened when defendant initiated the proceeding under section 145 CRPC in case number 128 M 1996 and cause of action accrued on several dates and final being 29/11/1999 when the final order was passed. I have perused the plaint and relevant documents submitted by the plaintiff and is of considered opinion that the cause of action finally accrued on 29/11/99 and the plaintiff instituted the suit on 24/1/2000. This is within the period of limitation as such the instant suit is not barred by limitation, my lord. This is the
When the executive magistrate pass an order for attachment under section 145.
yes, my lord.
Complaint is filed by you.
Yes, my lord.
Complaint was filed by you.
Yes, my lord.
This shall be in short complaint. Where is the land be attached under 145? Or what are the preconditions of attachment of land under section 145?
My lord, when there is a breach of peace, public tranquility, and apprehension of the danger and threat to the possession of the land, my lord, regarding, then the executive magistrate draw up the proceeding, and when there is a forceful dispossession regarding the possession of the land, then he attests the.
It is not your case that you were in possession. You went to court, got an attachment of land when you are in possession.
My lord, when I was at the, just after execution of the agreement for sale, I was delivered possession, my lord.
Correct.
Yes, my lord.
Understand from your submission
Yes,
that you are you were in possession of the land. You filed 145 proceeding and you got your own land attached when you were in possession.
my lord, just after he got the periodic paper, my lord.
I am agreeing to it. So that means while you were in possession, you got your land attached.
Yes, my lord.
Correct. You have the 145 order here.
Yes, my lord, and 145 order is also here, my lord.
Under CRPC 145, is that permissible? That when there is apprehended breach of peace, I on my own land to get an attachment.
When the opposite party become desperate, forceful, and their instrument is the registered deed, my lord, to house the disposes the proper
This the provision and then tell us.
then the learned magistrate compelled to attach the suit land, my lord, and there is a direction to the both parties, my lord, not to enter the suit land, my lord.
When you can't be in position, you got a land attachment, then you are not in position.
My lord, then second party, during the proceeding of the 145 proceeding, he and forcefully entered in the suit land and developed and constructed dwelling houses, my lord, also digging the fisheries and everything he has done, my lord, during the proceeding 145, my lord. And that is also illegal construction, illegal digging, my
I
lord.
am not deciding 145 proceeding. Asking you a question, because you are feeling that the land should be part by limitation. He projects that when the final order of attachment was passed on certain date, within a few months he came and filed the suit. 1911 or something. What is the date? I forgot. 29/11/99.
2011, 29/11/99, my lord. My lord, then I am going to the appellate court opinion, my lord, regarding the limitation act, my lord. Your lordship again kindly see page number 26, my lord. Page number 26, appellate court view opinion regarding the limitation act, my lord. Issue number 2, page number 26, my lord, 18 paragraph number. This issue has now become a reductant one. The appellant claimed that the respondents were never in occupation of the suit land, and it is the appellant who has been in possession of the suit land on the basis of the agreement for sale. With this, the appellant intended to mean that the respondent actually filed the suit for recovery of possession. The appellant pleaded that the cause of action for the suit arose on the day when late Abdul Ali purchased the land, and after expiry of 3 years thereafter, he filed this suit, and for that matter, the suit is barred by Article 113 of the Limitation Act 1963. The respondents, on the other hand, claimed that on 29/11/99, when the learned executive magistrate passed an order declaring the possession of the appellant over the suit land, the cause of action for filing of the suit arose. The learned counsel for the appellant submitted that Article 113 of the Limitation Act is applicable in this case. The learned counsel submitted that the respondents purchased the suit land on 14/5/1996, and they were never in possession of the suit land, so they should have filed the suit within 3 years of the said purchase. On this point, I beg to disagree. It has already been proved in evidence that the respondents have been in possession of the suit land, and the appellant never came to occupy the suit land. Here, in this case, in my considered opinion, Article 58 of the Limitation Act is applicable.
That part of the proposition is incorrect. Come to page 11. Page 79. 145 must be deleted.
It's 79, my lord.
Page 79.
Yes,
The
ma'am.
district start, the above statement of deed number 1 is very important in this case. Deed number 2 to Masipur Ali Chaudhary stated their demarcated land was so and so, and he lastly said, one Chaudhary had handed over possession of the disputed land to the second party, so and so. Name I can't name. Very light. And therefore, he stated to be in possession. Now, after all the discussion about 15, 20 pages, about 19 pages, now you come to page 87. In 87, it says that you have a right to be possession, and therefore the land is attached, the attachment order is vacated, and proceed is directed to hand over possession in demarcated land to first party. So therefore, when this order is passed, giving you the position, then he says my right is increased, and he comes to file a suit.
My lord, in this case, my lord, the plaintiff respondent has feeling from the very beginning, my lord. For the first time, he said, when the first he purchased the land in the year 1996, Hereafter, 145 proceeding draw across the land, my lord. Then he was, I am in possession or I am deprived by his forceful action. That is not a matter, my lord. When there is a direction from the executive magistrate that the both parties should not enter into the suit land, my lord, he does not feel that he should go to the civil court, my lord. He, without obedience, he ignoring the order of the learned magistrate, my lord, he forcefully entered the suit land and he developed the construction, my lord. Hereafter, my lord, what's happened? In the meantime, while there is proceeding, my lord.
Done or not, you did not file a counterclaim asserting your right over the land. And it is admitted by the executive magistrate that by deed number 514, possession handed over to the defendant. Sorry, respondent. That is an admitted fact. But it comes to a finding that the land was forcefully was entered into, and this thatched house was built in violation of the orders passed by the magistrate. He says now vacate the land. Tell me if I'm correct, because I don't read the authority. I read here and there and jump to conclusion.
That's correct.
So that gives him the cause of action. How can we demonstrate that it is not? The executive magistrate says that he was in possession. So illegal. And then he was ordered to vacate the land. You see, illegal possession based on title.
My lord,
You entered into an agreement when?
my lord,
With the wife, you entered into agreement when?
14,795.
1495, my lord.
14,795
Yes, my lord.
is the agreement for sale. 14,795.
Yes.
That agreement for sale was not,
Agreement for sale, yes, 95,
specific
my lord.
performance was not sought for. The title becomes paramount. It precedes the agreement for sale.
Yes, agreement for sale. Specific performance of contract was also filed, my lord. But during the proceeding of the pro forma defendant, Azizur Rahman Chaudhary vendor was expired, my lord. And it became infractious, my lord.
No, agreement for
It
sale.
is, but it is not in the record, my lord. It is on the basis of the title suit, my lord, filed by the plaintiff respondent.
Whatever be there, but
That is a different case, my
it's
lord.
not on record.
That is that is only on the
Because
pro
the
forma
title will have
defendant.
precedence. Your agreement for sale can't have any title to contest the title of the respondent.
My lord, I am going to the different opinion taken by the first trial court, my lord, and the first appellate court, my lord. And how they define the limitation act, my lord, and how they have taken the limitation article 113 and article 58 of the limitation act, my lord. First I have told, I have stated that is on the order passed by the trial court, my lord. Now the appellate judge court, my lord. I am going to the learned counsel for the appellant submitted that the article 113 of the limitation act is applicable
where?
in this case.
You're reading where? Which page you are reading?
Page number 26, my lord. The learned counsel have submitted that the respondent pursues the suit land 14/96 and they were never in possession of the suit land, so they should have filed the suit within 3 years of the said parcel. On this point, I beg to disagree. It has already been proved in evidence that the respondent having in possession of the suit land and applicant never come to occupy the suit land. Herein, in my considered opinion, Article 58 of the Limitation Act is applicable. Article 58 states that in order to obtain a declaration as paid for by the respondent, the suit has to be filed within 3 years from the date when the right to sue first accrued. There is a basic difference between Article 58 and Article 113. Article 58 speaks about the accrual of right to sue for the first time, whereas the Article 113 simply states that the suit has to be filed within 3 years of the accrual of right to sue. In the instant case, the pleadings clearly show that when the learned executive magistrate passed the order dated 29/11/99, the respondents developed the apprehension that their title over the suit land has been threatened. Therefore, right to sue first accrued on 29/11/99. My lord, the brothers of his brothers opined that the final right to sue is on 29/11/99, so the plaintiff has filed the suit in the year 2000. There is according to him, there is no time bar of this filing the suit. And the learned evidence court defined that 58 is applicable, and as per Article 58, when the plaintiff has a first right to sue, accrual of the first right to sue. So 29/11/90, when the final order is passed, my lord, and learned appellate judge defined that and counted the period starting from the final order of the my lord. Then what is that is the first cause of action, attachment order. What is the date of the cause of action? That is the registration of the
In one particular
my
proceeding,
lord, my lord.
in one particular proceeding, just tell me what would be the cause of action? You yourself say that you were in possession when you filed the case. That's why I asked you. You said that, no, I was in possession and I filed 145 protection by possession. So you were then there. So how would first cause of action arise at the same time to Mr. Dekha?
My lord, first cause of action is arise when the plaintiff pleaded in the plaint that the first cause of action
He said
on that
1911
is-
only.
Yes, my lord, I am
Then-
going through the plain, my lord.
Then 2911, that's it. Cause of
I am
action.
going through the plain, my lord.
There is only one cause of action.
I am going through the plaint, my lord, here. Page number 49, my lord.
There is this
Page number
only one cause of
49.
action.
Page number 49,
What is the
paragraph number 14. It is plained by lord, my lord, that the cause of action for the suit arose on 13/11/96, the date on which the executive magistrate attached the suit land. 29/11/99, the date on which the final order was passed by the learned executive magistrate, declaring the defendant was in possession of the suit land. My lord. My lord, plaintiff himself pleaded in the plaint that the first cause of action on 13/11/96.
That's why we asked you that question first. Before you started, we asked the first question. Cause of action was the cause of action was 145. Arose when you were in possession, you said yes. If you are in possession, please tell me, even when he pleads, cause of action arose earlier. You can't admit that. If you admit this 145 case goes, he will be in possession on the strength of his title. So you are not accepting that. You are asserting that you are in possession. If you are in possession, this cause of action would only be 2911. The executive magistrate passes an order that he was in possession, he came into possession during the pendency of the case. And his possession is based on title. Your possession, your claim to possession is not based on title. It is based on the
Agreement.
the agreement for sale. It does not give you title. You take from the wife, he takes from the husband. Husband is the recorded owner. How can you contest his possession on the strength of wife's agreement for sale?
My lord, not only this, at the time of the presentation of the plaint, the mutation of the plaintiff and his vendor also cancelled by the this case number 10/97 passed by the Kamalpur Kamalpur Circle Officer due to the conspiracy, my lord, and till that there is no mutation in the record of the rights of the mutation of the present plaintiff
You know the strength of the
and
claim.
also the
No, no,
his vendor, my
this is the
lord.
first time you come to know
And
about the,
this fact is suppressed in the plaint, my lord, that
you
it is
see, as the title is extinguished, and you know the power of the civil court decree. Order of mutation is not dependent on, the title is not dependent on order of mutation or cancellation of mutation.
and the original paktadars, my lord, who are not impeded in this title suit, my lord, the mutation are restored in the original paktadars, and those paktadars are not impeded in the present title suit, my lord, and that is also
There is nothing on
pointed
record
out
to
to the
show.
court, my lord, and at the time of the framing of
Please
the
tell me, where is your agreement for sale?
in page number 61, my lord.
Page number
61,
one.
document number 1, my lord. Translated and typed copy, Mohammed Anjumara Begum. Now she is the legal heir, my lord, number 1, of wife of Khabir Ali. Case number TS 25/2000, death 4 civil justice. Azizur Rahman Chaudhuri Lekhame. Today I have taken cash rupees 24,000 and
where-
agreed to
where is
sell
sale
the
deed? And where is the sale deed?
sell deed, my lord. Sell deed, it is, my lord, I am not enclosed here. Sell deed is the, my lord, in the plain, my lord, LCR is available, my lord. It is in the plain. And your lordship kindly see page number 62, document number 2. Page number 63, in pursuance of the miss case number 10/95/96, an order dated 3/7/97
Just
passed
wait,
by
I am not in a hurry. Just wait.
the circle officer. The order of Sitha mutation was passed on 22/11/95 and 27/5/96. On the basis of the sale are cancelled and restored in the name of Sabek Paktadar.
We are bothered with mutation orders. We know what happens there. You have not claimed title. How do you contest this? By your defense, how can you contest the sale deed? Now, you come to page 52. 52 is the plaint.
Yes, 52 is the plaint of the last page of the plain, my lord.
Land is 1 bigha 2 kata 5 lecha.
Yes.
Covered by doc number 784,
Mm.
patta number 113. Correct?
Yes, of village Malibari under Moza Karora.
You come to page 61, that is your agreement for sale.
A plot of
Here,
land,
1 bigha
3 katha,
1 bigha 3 kata
5
5
lecha.
lecha, covered by doc number 784, and now ceiling number 238.
Patta,
We don't know. Ceiling number
238.
238 patta.
Yes.
Correct?
Correct, my lord. My lord, at the time of
No, no,
execution,
please.
this agreement, my lord.
Let me continue. Whether it is patta or ceiling number 238, but the title he's claiming is in respect of patta number 113 at page 52. How do you assail his title and possession? You two are in a different land. There's nothing on record to show that your patta 238 or ceiling number 238 is converted into patta number 113.
My lord, there is an order, my lord, circle officer's order. Ceiling land was given patta, periodic patta, my lord.
So if it is patta, it can't be ceiling. Ceiling surplus land when a allotment order is given, doesn't remain a ceiling patta.
Yes. Page number 62, comment, KP patta 113. Doc number 784, as per sale in place of patta, the land 1 bigha 3 katha 5 letra, Muhammad Azizur Rahman Chaudhary, son of Hamidullah, signed SDC 2211. As per sale in place of Azizur Rahman Chaudhary, the land 1 bigha so and so.
You're reading where? You're not
my
following
lord.
you. You're reading where?
Name and father's name, Samsul Ali, Harmuz Ali, in place of Harmuz Ali, inheritance. As per sale in place of
So
Passada.
you're just a land grabber. You have an agreement for sale for one land and then go and grab another land. That is why you don't purchase it from the original person. You purchase it from his wife.
My lord, defendant's wife purchased from the vendor, my lord, and that vendor executed the sale deed to the plaintiff, my lord. Land, suit land is same suit land, my lord.
Don't say purchased. You entered in an agreement for sale.
Yes, agreement for sale, my lord. And it was, he promised to execute the registered deed within 3 months, that is after getting the patta, my lord. But that was
Breach of
not
promise.
that,
You can sue for breach of promise.
yes, my lord.
How will you assail his title? Just tell me only one question. You have only one question. How do you assail his title? Based on what?
As I have no registered deed, I have no title, my lord. But I have the possession, but that was forcefully taken by the defendant, and learned executive magistrate confirmed my possession, and learned appellate revisional court also affirmed my possession, my lord. And that is on the, my position is only on the paper, my lord, not on the physical position, my lord, on the basis of the judgment of the record, my lord, passed by the executive magistrate who delivered the position in favor of the defendant appellant, and learned revisional court also confirmed my position in favor of the defendant appellant, but I have no title because I have no registered deed, and I am dispossessed only on the point of time just after execution of the registered deed by the vendor in favor of the plaintiff, and I am dispossessed, and I approach to the court, and during the proceeding of the attachment, plaintiff disobeyed the order, and he has done everything, my lord.
He goes to the favor of the appellant, certain question of law does not exist to be answered in your favor. Second, substantial question of law.
My lord, my humble submission is that how the trial court and the first appellate court tried to save the plaintiff respondent to how to save him from the limitation act, my lord. The plaintiff filed after expiry
You are
the
making an,
consideration of
you are
delay.
making an accusation which is very irresponsible. You can assail an order in so much words you can, but you are saying that the civil courts have come to the protection of the petitioner to protect him. That means an element of malice in law has come in. Now, if you allege malice in law, have you made these officers a party here? Have you taken leave of the court to prosecute the judicial officers who are protected under the
Yes,
Judicial Officers Protection Act 1860?
my lord, I am going through the only on the
Don't make
basis of the
irresponsible
record.
statements. You can stick to your brief, but once you exceed that, it will be very, very bad.
My lord, I am going only through the statement, my lord. My lord, I am going through the only to the depth of the cause of action, that is
You are accusing
29/11/99.
the court of siding with the respondent to protect his title and possession. It's a very serious allegation.
My lord, this is the wrong interpretation of the section 58, article 58. First decree was passed on
So the order may be
taking
bad.
the view that
The order
29/11
may be bad. Even the Supreme Court reviews its orders. Did you apply for review if section 58 interpretation was wrong? You don't do it. Come to an appellate court, this is not a ground that the appellant was protected by the court by issuing a decree, and you make a responsible statement. It's a duty to protect the judiciary, right from the Court of Judicial Magistrate second class till the till grade 1, will be protecting them.
My lord, I am going to the 29/11/99, when the learned
Please tell
trial
us, when
court,
you accuse the court, please tell us in which ground have you stated that the trial court and the first appellate court sided with the respondent to protect his suit by misinterpreting Article 58.
in Article 58, when the
Please tell us the ground first.
yes, madam, I am going to the first trial court, while delivering the judgment regarding the taking the account of the limitation act, my lord.
I am at times one track.
My lord,
When I have asked
29,
you to read the grounds, please tell us the grounds.
2911, first is the 2911/99 trial court has taken that it is the,
Please don't sidetrack. I
I-
should ask you a question. You are bound to respond. If it is there, please tell us. If it is not there, tell us.
yes, my lord.
You can't avoid the court query. Under 165 of the Evidence Act, even if the question is, what you call, the word irrelevant, you're still bound to answer it. Your option is only to say whether in the grounds it is there or not. You don't have a third option. Don't make irresponsible statements. We would be very, very harsh.
My lord, I am very sorry that I have, what I am stated may be wrong, my lord. What I have
Not
given
maybe.
may be
Please,
wrong, my
you
lord,
see,
but
don't qualify it. It is wrong if it is not there in the brief and you have argued. It is wrong. Irresponsible. You damage the institution.
my lord, the ground
You
of the
take away
appeal, my lord,
credibility of the courts.
my lord, while I am,
As if judgments can be purchased. In short, that is what you are wanting to say. Take very serious note of it. It's very easy for you to say this when you are not in front of that court. There are many people who go out of this corridor and then say that, oh, so many things about the judges. You have heard that.
sorry, my lord.
Now tell us what according to you is the interpretation of Article 58. What according to you should be the interpretation of Article 58? Tell us.
My lord, Article 58, I am going through the limitation act, my lord. Suits relating to declaration, to obtain any other declaration, 3 years, when the right to sue first accrues. And under Article 113, my lord, 113, suits for which there is no prescribed period, a suit for which no period of limitation is provided elsewhere in the civil, 3 years, when the right to sue accrues. And when the right to, according to 113, my lord, the plaintiff has right, every time the plaintiff has right to sue, my lord. Either from the death of the parties registered deed or from the death of execution of the attachment order, my lord, or from the final order, my lord. My lord, when 113 article is replaced by the appellate court, my lord, under Article 58, my lord, and 58 is more specific, my lord, to obtain any other declaration 3 years when the right to sue first accrues. So when the learned appellate court prescribes the section Article 58, and it is face to face, my lord, clear that the time first right to sue accrues on the first that when it is stated in the plain, my lord, first pleaded cause of action, that is 11/96, my lord, not in the final order, not from the date of final order. Two, 3 cases are pending in the court, executive court, revisional court, title suit. And from every final order, if the plaintiff takes that from the final order passed by the so and so court, this is the first beginning, my right to sue occurs, my lord. That is not the case, my lord. First is first when his right is infringed, my lord. there is no any definition of the last cause of action, my lord. There may be many last occasions, my lord, one after another. And there are two different opinions, my lord, two brothers are, my lord, regarding the Limitation Act. One specify 113 is applicable, and the senior judge applies the 58 is applicable. If 58 section is applicable, then there is a no the time but first right to sue accrues on the from the death of first cause of action when it is pleaded in the plaint, my lord.
What about question number 2?
Question number 2, whether by not affording opportunity to prove or disprove the additional issue as framed during the writing of the judgment, the trial court has committed illegality. In page number 22, my lord, last portion, settlement of additional issue can be done lawfully by the trial court, but it has to be settled under the provision as laid down in Rule 3 of Order 14 of the Code of Civil Procedure. In the instant case before me, I have found that the additional issue has been framed at the time of writing the judgment. This is a violation of the law laid down by Rule 3 of Order 14 of the Code. As the parties to the case never had the opportunity to prove or disprove that issue, this fact is a sufficient ground for remanding the case to the trial court for disposal of the additional issue. But I do not intend to remand the case to the trial court because of the fact that this case is an old pending case instituted in the year 2000. Moreover, the law pertaining to non-surrender of necessary parties in a civil suit is well settled. The parties without those present a suit cannot be effectively adjudicated upon are the necessary parties. Under the circumstances, I shall not discuss the additional issue pertaining to the non-surrender of the parties settled by the learned trial court at the time of writing the judgment. My lord, this is also a violation of the provision of CPC, my lord, because this issue was framed by the learned trial court at the time of the framing of the issues, but it is discussed at the time of the writing of the judgment, and regarding that issue, the learned trial court has not given any opportunity whether these parties are necessary party or not.
Yes, you are relying on any case laws?
My lord,
Are you relying on any case laws?
yes, sir. Another point is that it is not at the time of hearing, it is not cited, my lord. Regarding jurisdiction, my lord, the village, Malibari village under Bahata police station, their pecuniary and territorial jurisdiction is in the court within the subdivision and within the additional district and sessions as my lord, it is Romia, my lord. The title suit was filed in the Gauhati, my lord, senior division. After the verification, my lord, senior division transferred the case, junior division, Gauhati, my lord, trial court. But it should be transferred to the Rongia Judicial Magistrate, my lord. And the judgment is delivered, my lord, without transferring the title suit to the proper jurisdictional court, my lord. And it is the duty of the court and also a duty of the parties also, my lord, most probably, and that is the plaintiff side, my lord, and also the duty of the court to transfer the case to the proper jurisdiction, either pecuniary or territorial jurisdiction. But there is no any territorial jurisdiction of the learned court below Guwahati district, my lord. It is the jurisdiction of the Romia civil judge Munsif, my lord. And judgment is delivered, and without jurisdiction, judgment is decree and judgment is nullity, my lord. And if there is any consent of the parties or acquiescence or silence, and it does not amount, and without jurisdiction, lack of jurisdiction of the territorial inherent power, if there is no inherent power to deliver the judgment and decree, then that decree is nullity, my lord, and void.
Which paragraph of this? In which paragraph of this judgment?
My lord, in the forehead, my lord. First, or in the first paragraph, my lord. my lord, till today, this plaintiff respondent is not able to actual honor pattadar in the record of the rights, my lord. This is the latest Tamabandis copy.
Not record, with things which are not on record, we are not taking it. If that's one, Mr. Rebecca, yes.
Yes. Waiting, Lord. Lord, like your worship may have.
He's raising this issue of.
That doesn't find place in the memo I did find. Neither here nor in the first appeal. I'll just check the. Section 21 otherwise says it cannot be raised for the first time in appeal.
So whatever be, you deal with it.
Yes. I'll address this. I'll address this. After, should I address the questions formulated first and then come back to?
No, first come to the question formulated, then you can.
Yes.
Respond to this.
Lord, before I address the Honorable Court on the issue of limitation, my lord, few things your lordship will kindly note. First of all, this appears like your lordship has already taken note of. This is a contest between an unregistered agreement for sale versus a registered sale deed. Now, my lord, so far as the agreement for sale is concerned, my lord, in the written statement, they had said that a suit for specific performance is pending. However, in during cross-examination, my lord, they admitted that no case has been filed.
Where is that?
My lord, I have marked the cross-examination if your lordship has it.
The record DW1.
DW1. I flag marked it.
Just trying to see it. Yes, cross-examination is there.
Yes. Lord, should I read the, there are other relevant portions, very quickly, can I read it?
Just read the relevant part.
Well, first of all, first sentence itself, they admit they are not in possession. Bibadiyo mati bortoman badir dokholot ase, badir ghor ase, pukhuri ase, badir ghortut kuno nathake, prodorsho ko joge bibadiyo mati moi kinim buli baina korisilu. Then, the second page, I'll just read the extract, Prodorsho ko baina potror bolot.
Just a moment.
Yes.
Yes.
Lord, first, they admit that we are in possession, Lord, and the certified copy may not match, Lord. Prodorsho ko,
This is second page of my
Yes, প্রদর্শক
প্ৰদৰ্শক ক বাইনা পত্ৰৰ বলত বিবাদীয় মাটি ৰেজিষ্টাৰ্ড ডিড যোগে বিক্ৰী কৰিবলৈ মই বা মোৰ পত্নী প্ৰফৰ্মা ডিফেণ্ডেণ্ট নম্বৰ 2 আজিজুৰ ৰহমানৰ বিৰুদ্ধে দেৱানী কেছ কৰা নাই।
Yes.
However, at page 55 of the appeal memo,
Yes.
my lord, just above paragraph 10, my lord, the last sentence of paragraph 9, and Anjuara Begum has instituted a suit for specific performance in the court of Rongya, and it is pending disposal before the court.
Yes.
So no particulars were furnished. However, during cross-examination, he admitted that they have not filed any, neither he nor his wife has filed any suit against the pro forma defendant for registration of the sale deed. Now, in that very same WS, if your lordship has page 57, my lord, I'm sorry, page 58. Page 58, paragraph D.
Yes.
That the continuous possession of the suit land continues to be with the defendant number 1 and his wife until now, and during July-August 1996, the defendant number 1 had cultivated paddy, and after it became nurtured, so-and-so was pleased to direct OC Bokhisto Police Station to sell standing paddy in public auction on a wide order dated 13/11/1996. So this statement that they were in possession until now, that is till the date till the filing of the written statement, is also belied, because the very first sentence of the cross-examination, they admit that we are in possession. Now, the cross-examination of defendant number 2 is also in similar lines. He admits that we are in possession and we have we have houses on that particular land. DW2 also admits that. So what transpires from all of this is, my lord, first of all, they have an unregistered agreement for sale, not enforced till date. Secondly, we are admittedly in possession of the suit land, my lord. So now the question that now is sought to be raised is the suit barred by limitation, and when will the cause of action accrue in terms of Article 58? So, my lord, the moot argument, if I have understood it correctly, is that the first cause of action would accrue on 15/11/1996. That is the day on which the suit land was attached by the executive magistrate for the first time. Rather than on 29/11/1999, when their possession was declared. Lord, I pose this question to myself. Is it the law that the moment a land is attached, without awaiting the conclusion of the proceeding under 145, 146, one has to rush to the civil court to seek a declaration under 58? Well, that would, in my respectful submission, I tried to find judgments directly on this. I couldn't, but what I have gathered is, when the attachment is ordered under 146, Manoj,
We give us an easy way. We pass the judgment and then you'll have not, don't have to find it.
I can rely it on the next. So, Manoj, 146, Manoj, if I've understood it correctly, Manoj, that is just a holding measure, 146(1). The property in question is merely kept in custodia legis to find out eventually who will be entitled to possession. So rather than an order in favor of a party concerned, it merely puts the property in the custody of the executive magistrate. So that, in my respectful submission, would not by itself lead to a cause of action for me to rush to the civil court without awaiting the final orders under 145(6). Now, Lord, 146(1), once an attachment is ordered, it is just pending that inquiry. Now, eventually, when the final orders under 146 is passed, 145 subsection 6 is passed, it merely declares the possession or the notional possession of the party concerned. And then again, it leaves it to the aggrieved party to sort of get an order from the competent court. And that is how the cause of action, according to us, would accrue on 29/11/1999. Well, though not in the context of limitation, Manoj, if I'm allowed to rely on a particular judgment, this is Shanti Kumar Panda versus Shakuntala Devi, 2004 1 SCC 430A. So what does a person agree? But the law itself provides under 6 that the person agreed these orders would remain subject to orders of eviction that may be passed in due course of law, and the aggrieved party therefore can again ventilate his grievances before the competent court of law, which is the civil court. Paragraph 12 of that judgment, if you lordship, I'm just trying to sort of borrow the analogy to argue that it is not until the final order under 145(6) that I need to straight away go to the civil court, because throughout, until that order is passed, it is in custodia legis, and which is why the other proposition of law that I need not even claim for recovery of possession. So executive magistrate is only holding it for the rightful person who's entitled for possession. Paragraph 12, what is an eviction in due course of law within the meaning of subsection 6 of section 145 of the code? Does it mean a suit or proceeding directing restoration of possession between the parties respectively unsuccessful and successful in proceedings under 145, or any order of a competent court which, though not expressly directing eviction of the successful party, has the effect of upholding the possession or entitlement to possession of the unsuccessful party as against the said successful party? In our opinion, which we would buttress by reasons stated shortly hereinafter, Ordinarily, a party unsuccessful in proceedings under section 145 ought to sue for recovery of possession, seeking a decree or order for restoration of possession. However, party, though unsuccessful in proceedings under section 145, may still be able to successfully establish before the competent court that it was actually in possession of the property and is entitled to retain the same by making out a strong case demonstrating the finding of the magistrate to be apparently incorrect. In a case where attachment has been made under 146(1), it is not necessary for the unsuccessful party to seek the relief of possession from the court. A mere adjudication of rights would suffice inasmuch as the attached property is held custodia legis by the magistrate for and on behalf of the party who would be successful from the competent court by establishing his right to possession over the property. Mr. So-and-so, the Earnest Senior Counsel for the appellant, submitted, reading literally subsection 6 of section 145 of the code, the declaration of the successful party to be entitled to possession thereof until evicted therefrom in due course of law, and forbidding all disturbance of such possession until such eviction, means that the Parliament intended to confer a binding efficacy on the magistrate's order, not only qua the parties to the proceedings, but also qua all concerned to respect and abide by the order of the executive magistrate. And such order and the possession of the successful party protected thereunder shall continue to survive and hold valid and good, unless at the final adjudication of the civil rights, the competent court has directed the party successful in the proceedings before the magistrate to be evicted, whence and whence alone that party shall lose possession and bound to hand over the same to the party successful in the civil court. It is settled law that a decision by a criminal court does not bind the civil court, while a decision by the civil court binds the criminal court. A decision given under section 145 of the code has relevance and is admissible to evidence to show that there was a dispute relating to a particular property, that the dispute was between the particular properties, that such dispute led to the passing of the preliminary order under 145(1) or an attachment under 146(1) on the given date, and 4, that the magistrate found one of the parties to be in possession or fictional possession of the disputed property on the date of the preliminary order. The reasoning recorded by the magistrate or other findings arrived at by him have no relevance and are not admissible in evidence before the competent court, and the competent court is not bound by the findings arrived at the magistrate, even on the question of possession, though as between the parties, the order of magistrate would be evidence of possession. The finding recorded by the magistrate does not bind the court. The competent court has jurisdiction and would be justified in arriving at a finding inconsistent with the one arrived at by the executive magistrate, even on the question of possession. Section 145 and 146 only for the order of the executive magistrate made under any of the two provisions being superseded, and by giving way to the order or decree of the competent court, the effect of the magistrate order is that the burden is thrown on the unsuccessful party to prove its possession or entitlement to possession before the competent court. So it is only after that order of 29/11/99 had been passed, the burden had been thrown onto me to establish my right before a competent court. And prior to that, my lord, it was merely under attachment. It is not an order in a party's favor or in favor of the other or against a particular party. So therefore, my lord, the mere attachment on 15/11/1996 was not a right cause of action for me to approach the civil court. At any case, perhaps this order may have gone in my favor, in which case the matter would have been settled, and the need for approaching the civil court may not have arisen with it. Coupled with this proposition, my lord, like I've already submitted, first of all, I have a concluded sale. They do not have a counterclaim, my lord. I have settled possession over the property, as is evident from the cross-examination of the DWs. Therefore, there is no cloud over my title, so to call, and therefore, I need not have approached the civil court prior to the order passed on 29/11/1991. And the suit filed in 2000 was within time. Now, my lord, insofar as now both the courts, and in any case, my lord, limitation being a mixed question of law and fact, this is again dependent on whether I was in possession or not. Because if I were out of possession, then perhaps they may have argued that the moment I lost possession, I should come either in terms of 65 or 58. That would be the starting point of time. The courts have held that I am already in possession. So therefore, the need to approach the civil court did not really arise, my lord, and whether I was in possession or not, that being a question of fact which has been decided by the learned trial and the first appellate court, this part of that mixed question cannot be re-agitated in a second appeal. Now, my lord, the second question of law, my lord, of course, there was a difference of opinion between the trial and the trial court and the learned appellate court, my lord. While the trial court holds that since you have taken up the plea and this can be decided on the materials available on record, the trial court went on to examine the issue of non-joinder. Now, while examining the issue of non-joinder, it came to a categoric finding that since both the parties are essentially saying that Azizur Rahman Chaudhary is a pattarar, and both of them are in one way or the other trying to borrow title from that same source. So this question of non-joinder does not even arise. That was the precise finding of the trial court. Now, the first appellate court, of course, says that that exercise should have been done prior in point of time and it could not have been done at the time of writing of the judgment. Now, my lord, to this, my lord, I would only say, my lord, even if we go by the trial court judgment, any prejudice that is likely to be caused for non-framing of that issue will be only as against me, because I am the plaintiff and they've already named the persons concerned. So if that particular issue would have been raised, adjudicated upon without putting me to notice, it is me who would have suffered the prejudice, because I would have lost out on an opportunity of exercising Order 1, Rule 10 to implead those parties. Insofar as they are concerned, their issue, the issue was raised by them and it was addressed by the courts. So therefore, there is absolutely nothing to prejudice them. And going by that settled position of law, that when the parties know their cases, and they have led evidence in support of their respective cases, then non-framing of an issue will not be fatal, So I would say that even slightly disagreeing from the reasoning of the learned appellate court, I would say the trial court had this is that famous judgment of this basically for that proposition that non-framing of issue is not fatal when parties went to trial fully knowing their rival cases. That is paragraph 5. But I need not trouble your lordship with this settled position. Paragraph 5. So the issue itself was not based upon substance, in the sense that since pro forma defendant was already on record and it was a dispute inter se between the plaintiff and the defendant who were claiming title from the admitted owner Azizur Chaudhary Manoj. No, because it was nobody's case that he was not the owner. Today, of course, some mutation entries are shown to suggest that he may not have been the owner, but it would be dehors the pleadings, because both the parties have consistently said that Azizur Chaudhary was indeed the pattadar. So consideration or no consideration doesn't substantially affect the right of the appellant, so hence it cannot be construed as a substantial question of law. This, of course,
On this, I would have a different view. See, once a question is framed,
Yes.
we can't say at the time of adjudication that this question does not arise.
Yes.
You only have to answer it.
Yes.
Substantial question of law framed by the court.
Yes.
Subsequent in point of time, the court cannot say that there is no substantial question of. That is already attained finally. So we have to answer it.
Well, I would say, subsection 5, subsection 5 of 100, notwithstanding that it has been formulated, perhaps
It can be reheard and it can be, reframed. But it's not open to the court to say that, no, I would not answer it, there is no question arise.
of course, that limitation is not against the respondent, but perhaps, yes, the court has to answer it. Because it says the appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the be allowed to argue that the case does not involve such question.
Does not
But-
involve.
Yeah.
You can argue that, but you have to answer it, whether it is involved or not.
Yeah.
Can negate that by saying that there is no question arises, therefore we don't argue it, so we don't answer it. Answer has to be made.
Lord, I was only trying to say, Lord, that this substantial question would not substantially affect their right, because regardless, so, Lord, it may not involve that question in the case at hand. Lord, so far as the point of jurisdiction is concerned, I must admit I'm taken a little by surprise, Lord. Because this is an old pending matter, I'm not sure whether at that particular point of time the subdivision of Romeo was.
Kamrup, if I understand correctly, it's in 2003 that it was bifurcated.
Oh.
Judicial courts, I think, was set up by 2004. But at the time of judgment, it was in 2004.
Yes.
Right?
Yes. Judgment suit was instituted in 2000. And
2004, see that Kamrup Metro was notified. Just checking on mobile, you'll get it. When Kamrup was bifurcated, 2002 or 2003. Judicial courts, I think 2004. Started.
Lord, March 31st, 2003. Lord.
See,
Yes.
okay, and the judicial courts were a year after.
Yes.
Just check up second, when was judicial court inaugurated? Judicial court in Kamrup, Amindgaon.
But the bifurcation happened, it says in 2014, this of course, Aminga was then set up. But perhaps my friend has argued that Rongya subdivision, maybe it was under Metro, was existing.
Could be, we don't know, but we'll find it out, don't worry.
I'll try to find out and provide, if I get the
And,
notification.
The judicial courts in Kamrup rural started when?
2014 it says,
14.
subject, February 19, 2014. Because I remember it happened after we joined. Has to be post 2009.
I'm wrong by 10 years.
Subject to correction. This is what I found in.
No, maybe,
So the appeal could not have gone then, because appeal is of 2008.
February 19, 2014. So Musip could have been in Bangia.
SDJM was there, my lord. The civil charge is not.
We'll find it out, don't worry. We have the data.
No, this, of course, this section 21, I'm not sure how it has been dealt with in this judgment, my lord. Because essentially it's a question.
In this judgment, 21 was not dealt with because this was, the writ petition, the matter was with regard to the suit valuation. It says when the suit was valued, it would have gone to the appellate court, different appellate court, and therefore it was without jurisdiction. The Supreme Court says that even at the collateral challenge can be made on jurisdiction.
Notwithstanding 21.
21 is territorial jurisdiction. This is not territorial law.
Yes, yes.
This is pecuniary because of the court fees.
Okay.
The appellate jurisdiction would have been different.
Yes. Well, 21, 1 and 2, I reckon they deal with both place of suing and also pecuniary limits of jurisdiction.
Please see that the judgment. Even I did not get. But again, I read.
My lord, this judgment is pre-amendment. Because 21, 1 and 2 were inserted in the amending act of 1976, my lord. But this is of 1954.
That is why 21 is not there in this.
The head note mentions 21, not the body. The qualifying words are unless there has been a consequent failure of justice.
Yes, okay.
So, my lord, eventually, even if possession for some reason, the findings by the executive magistrate are taken into consideration, even on the count of title, my lord, I succeed in that case, the orders of 29/11/1999 would not come in the way for declaring my right title in case.
And just for the bar, you may leave because I'll dictate this order. It's going to take some time. I'll be dictating this order.
My item was, I don't know, 5. It will take time, your lordship.
Yes, because this is an order I'll be dictating. Otherwise, this is such a voluminous record, I would miss many things.
Lord,
When I take this home.
please, pass about
It will all be possible.
lordship.
But we have Sultana Dora, counsel for the appellant. And also heard the PD record on it. Counsel for the for all the respondents,
Yes, please.
for the respondents. That's one.
Not 9, not 10.
This appeal under section 100 of the CPC has been filed to assail the first appellate judgment and decree dated 15/6/2010, passed by the learned civil judge within bracket senior division bracket close number 2, County Metro Gauhati, in title appeal number 13/2008, by which judgment and by which the appeal was dismissed and the judgment and decree passed by the learned civil judge within bracket junior division bracket close number 2, Gauhati, in TS number 885 of 2006 was, thereby dismissing, declaring the suit was allowed. That the decree was dismissed. And, well, decree was affirmed. Is the wrong word. Affirmed. It's correct.
In the, but see there on the appellant herein is the defendant and the respondent is the plaintiff in TS 25 of 2000, which was subsequently re-registered as title suit number 885 of 2006. Next part. The case of the respondent dash plaintiff is that he had purchased a plot of land measuring 1 bigha 2 katha 5 lecha covered by DAG number 784 of KP Patna number 113 of village Malibari, Malibari, Moza, Karara, Karara, in the district of Kamrup. Within bracket, as it was then, comma, now located in district Kamrup, Amingao. Kamrup, undivided Kamrup. Full stop. The land was purchased by sale deed number, registered sale deed number 514/96 dated 14/5/1996 from its recorded owner and patadar comma, namely comma, Mohammad Azizur Rahman Chaudhary, CHOUDHURI, right, comma, the proforma defendant in the suit. And upon purchase, comma, the land was mutated in the name of the respondent plaintiff. It is posited that after execution of the sale deed, comma, possession of the land was taken over, but the appellant filed a petition under section 145 CRPC before the executive magistrate, which was registered as case number 128 superscript M oblique 96, alleging that by an agreement for sale dated 14/7/1995, comma, the wife of the wife of the appellant entered into an agreement for sale with the same vendor, comma, the proforma defendant number 2. Sorry, he's a proforma respondent here.
Yes, he is respondent number 9 and appear for 128.
Full stop. Initially, the said land was attached by the learned executive magistrate by order dated 15/11/1996. What is this 7497 order?
It was
What is that?
vacated, my lord, then it was reattached in 10/9/97.
It was vacated.
It was vacated on 7/4/1997.
Okay. It's projected that by an order dated 7/4/1997, comma, the order of attachment was vacated. So how, comma, by subsequent order dated 12/6/1997,
the order of attachment was vacated and the respondent plaintiff was handed over the position of the suit land. Where is this order?
The plaintiff was declared to be in possession. I'm sorry, the defendant was declared to be in possession by that order of 2911.
No, in page 46, you say plaintiff was given possession.
Yes, yes. Well, that's prior to the attachment.
You were given possession. Where is that order?
I'll prove it.
The respondent was given handed over possession of the suit land. Stop.
Exhibit 5.
Agree by the order dated 12/6/1997, the appellant approached this court and this court by an order dated where is the order of this court? It is not there. This court had stated to have vacated the attachment order. Passed in Criminal Revision 79/1999. And the executive magistrate was directed to attach the suit land and pass necessary orders after hearing both parties. Accordingly, the executive magistrate again reattached the disputed land and issued both sides to appear for the inquiry. And accordingly, the officer in charge of Gauhati Police Station executed the order dated 10/9/1997 and attached the suit land. Subsequently, by an order dated 29/11/1999, the position of the appellant was declared in respect of the disputed land, and direction was issued to the respondent plaintiff to take away the thatched house within 2 days. The respondent plaintiff filed a revision before the learned sessions judge, Pembroke, which was registered as criminal revision number 79 of 1999. And the said learned court by order dated 18/12/1999, was initially state the operation of the order dated 29/11/1999 by the order passed on 18/12/1999. How by final order dated 29/11/1999, the position of the appellant over the suit land was disputed land was declared. Accordingly, alleging that the cause of action for the suit arose on 13/11/1996, on the date on which the executive magistrate had attached the disputed land, and 29/11/1999, when the final order was passed by the executive magistrate from alia in case number 128, superscript claim of the 96, by which position for the suit land was declared in favor of the appellant. Suit was filed. Suit being TS number 25 of 2000 was filed for declaration of right title in and interest of the plaintiff on this over this land, semicolon, confirmation of position of the plaintiff, semicolon, and for permanent injunction in favor of the plaintiff. Cost and other debts. Next. The respondent appeared in the proceeding of TS 25 of 2000 and filed its written statement alleging that the respondent plaintiff had no right that in the interest of or position of this land, and asserting that the land was that in respect of the land, agreement for sale was executed by performer defendant number 2 in favor of the wife of the respondent. For me, it was stated that the vendor had no right title in interest or position over this land, and therefore the seal deed in favor of the respondent plaintiff was false and fabricated and had no legal effect. Positing that the appellant was in possession of the land and carrying out paddy cultivation. Comma. By referring to the position as by the executive magistrate in the proceedings under section 145 of the CRPC, it is alleged that the
with a further direction to the respondent plaintiff to remove the thatched house constructed by the respondent during the time when the attachment orders was vacated. Claiming that the appellant was in owner and possessor of the plot of land measuring 1 bigha, 2.5 acres, covered by Pata number 113 and DAC number 784 of village Malibari, MALI, BALI, Mozart, Karara, KARARA, by virtue of agreement for sale dated 14/7/1995 between the between Musammat, MUSTT, Anjuara, ANJUWARA, for the wife of the respondent and the wife of the repellent. And Mohammed Azizar, AZIZAR Rahman, about performer defendant number 2. Followed by Khas position and Khas position by delivery of physical position of the suit line. Also stated that the it is further stated that the performer defendant number 2 took a sum of rupees 24,000 as earnest money on the day of execution of the agreement for sale dated 14/7/1995 in presence of witnesses with condition that with an agreed condition that we will execute the sale deed, the registered sale deed after the periodic pata of land was received. It also projected that the performer the performer defendant number 2 took the earnest money of rupees 24,000 and on the same day executed Baina Patra on 14/7/1995 in the presence of the writer of the defendant number one, with the condition that the salient of the suit line will be made after issuance of periodic kata. Accordingly, I was obtained as the proposed defendant number two, tried to dispossess the appellant breach of peace, and accordingly the appellant had filed proceedings under section 145 of the 146 RPC before the subdivisional judicial executive magistrate accordingly it is alleged that the respondent was not in physical possession of the disputed land accordingly that the appellant was not in possession of the suit land and the balance of convenience was in favor of the appellant, being in possession of law, possession of the suit property, it was made to dismiss the suit. The learned trial court framed following issues on 21/1/2023, 2003, page 32. Well, deciding the state issues of the ballot, Municipal number 2, Gauhati claims that additional issue is following effect. Whether the suit is bad for non-general or necessary party, question mark. Next one. The learned trial court referring to the additional issue framed the
Accordingly, in respect of additional issue, it was held that the suit was not bad for non-joint or necessary parties. The respect of issue number 3, 2, 5, and 3, on the other trial court held that the suit was barred by limitation. So, barred by limitation filed with the, barred by limitation as the final cause of action arose on 29/11/1999, and the suit was instituted on 24/1/2000. In respect of issue number 3, it was held that the execution of Exhibit 1 was proved by the PW2 and accordingly how many witnesses were examining?
Two from the plaintiff side, you know,
Hmm?
two from the plaintiff side. Page 38, your lordship finds. I'm sorry, 5 from the plaintiff, 2 from the defendant. Page 38.
38. Is it 50, comma? The respondent plaintiff was held to have the right at interest for the and possession of the suit land in respect of issue number 1, it was held that there was cause of action for the suit. In respect of issues number 4 and 5, and the additional issues or the learned transport held that the respondent plaintiff was entitled to get declaration of his right title interest in confirmation of possession of the suit land. The suit was decreed first. Next, the first report
on appreciating the evidence and feelings of record. The It will be stated after hearing the counsel for both sides, the learned first appellate court was of the view that the point of determination in this case was as to whether the respondents have right, title and interest for this plan. First of all, regard to the additional issue, arrived at the finding that the additional issue was framed at the time of writing the judgment, which is in violation of law. Later on the order 14-3 of this PC, as the parties to the case was not given an opportunity to prove the said issue. Accordingly, the it was held that in view of the admission, the evidence of the appellant had lost relevance in the present case, resulting, after discussing the issues, issue numbers 1 and 2, instead of the issues in favor of the appellant. But accordingly, we see counsels on issues number 4 and 5 were affirmed.
And accordingly, the appeal was dismissed without any authorized cost. Next. The, this appeal was admitted for hearing by order dated 31/7/2012. The following effect. Page 13, 14 order sheet. You look like. Number one, whether the suit is barred by limitation in view of the provision of Article 58 of the Limitation Act from 1963 on the basis of the pleaded cause of action by the plaintiff. Number two, whether by not affording opportunity to prove or disprove the additional issue as framed during the writing of the judgment, the trial court has committed illegality. Next part. Referring to the facts of the case. It has been submitted that the suit was brought for non-tender of necessary parties. As there were other patta holders, presence was recorded, was mentioned in the written statement of defense filed by the written statement filed by the appellant. Stating that Achina Bibi, ACHINA, Achina Bibi, Samad SAMAD, Samadadi, and Anju, ANJU, next word ARA, and Egam are necessary parties to the suit. It's also submitted that as per Article 58 of the schedule to the Limitation Act, which relates to suits relating, which is in respect of suits relating to declarations, at the time of limitation to obtain any other declaration is 3 years when the right to sue first accrues. Full stop. Referring to the statements made in the claim, I have submitted that as per the statement made in paragraph 14 of the plaint, the cause of action first arose on 13/11/1996
on the date on which the executive magistrate had attached the suit land, it is submitted that the subsequent cause of action arose on 29/11/1999. Mr. How, 2019, the date when the final order was passed by the executive magistrate. In this regard, it is stated that as Article 58 of the Schedule to the Limitation Act refers to the right to first sue, the said cause of action had arose on 13/11/1996, and therefore the suit which was filed on
24/1/2000. 24/1.
24/1/2000, was barred by limitation. So it is stated that although the land was in possession of the appellant, and only in course of the proceedings before the executive magistrate, the respondent had taken over the possession of the suit land by dispossessing the appellant. So stated that in the written statement, in certain paragraph 9 of the written statement, and specifically was taken that the appellant had filed a suit for specific performance of contract. It's submitted that although no ground has been taken, the effect that the decree is passed by the then it's civil judgment the junior division that was number 1 from Gauhati, and the appellate judgment and order passed by the learned civil judgment bucket. Senior division. It's senior division Gauhati. But the courts, the Court of Munsif, civil judge within like a junior division, and Rangia subdivision was the jurisdictional court, and therefore, after bifurcation of the district of Kamrup into two, the proceedings before the Court of Civil Judgment in bracket junior division bracket will go two at Gauhati, which is in Kamrup Metro District, And the consequential appeal also without jurisdiction. In this regard, reliance is placed on the decision of the Supreme Court of India in the case of Chandra Bhushan Khanna and others versus Brij Nandan Singh last time. It was held that the court lacking if the court lacked inherent jurisdiction to try a suit, consent, waiver, or acquiescence by parties to the suit cannot confer it. By further holding that delay in taking objection to jurisdiction in court cannot be a ground for conferring jurisdiction impliedly. There was one order, this is the order, there was any other order? We give you a judgment? Yes. Which one, where is that? 1954. That one. Put up by. This is the case of number one, huh? Chandra Bhushan Khanna and others versus Brij Nandan Singh and another, AIR 1978, Allahabad 459. As well as the case of Kiran Singh and others
versus Chaman, CHAMN, Chaman Paswan and others, PI 1954, SC 340. Then this first case is discussed. Number 2. The case of Kiran Singh within bracket Supra was just on the point that a decree passed without jurisdiction is a nullity. Next. Next. Current contract from the learned counsel for the respondent. Had submitted that though the ground of non-general necessary parties was taken from the it was not best when the issues were framed. Moreover, it is submitted that though the learned counsel for the appellant is projecting that they were in position that the appellant was in possession of the suit land, but in cross-examination of PW1, DW1, what is the name of witness?
The Samir Ali.
Samir Ali, the defendant, appellant, had admitted that the land is in the possession of the respondent plaintiff. He submitted that as no suit for specific performance of contract was filed. This is a case where the appellant is fighting on the strength of is claiming title on the claiming possession on the basis of agreement for sale, whereas the said land was sold by the vendor by executing a registered sale deed. Number 514/96, right? Full stop. It is submitted that merely because the 2 dates of cause of action was mentioned in the plaint, but order dated 15/11/1996 was only an interim order of attachment, which makes the property be under custodial aegis, which is always subject to the final orders where possession is declared. So accordingly, it is submitted that as the appellant was held to be in possession by order dated 29/11/1999, the suit which was filed on (24/1/2000) was within the period of limitation prescribed under Article 48 of the Schedule of the Limitation Act. So, by referring to the to statement made in paragraph 14 within bracket E, sorry, D of the written statement. It is stated that the continuous possession of the suit land, the pleaded case of the appellant was that that they were in possession of the suit land. Which is contrary to the statement made in cross-examination by the appellant, comma, the cause of action would always be the date of 29/11 clause 1999, by which the respondent was declared to be in possession of the suit land. In support of the said submissions, comma, by referring to the case of is referred to the case of Shanti Kumar Panda versus Shakuntala Devi. Comma, within bracket 2004, bracket was 1 SCC 348. To support the submissions that during orders of attachment, the property is in custody and aegis of the magistrate who is holding the said property on behalf of the party who would be successful from the competent court by establishing his right to possession of the property. According to the submission that it will always be the civil court's order that will prevail and not the finding recorded by the criminal court, even if it is passed in a proceeding under section 145 CRPC. Next, regard to the issue of non-general necessary parties, comma, submitted that the parties had contested the suit knowing their respective case. Accordingly, the additional issue that was framed by the learned trial court at the time of writing judgment could not be patterned for either party. And therefore, there was no necessity to give any opportunity to the parties to prove or dispute the additional issue that's claimed at the time of judgment writing. Next one. This is the
the first substantial question of law is being taken up for decision. Also, the case of the appellant is that they were in possession of this land. This is also reflected in paragraph 14 within bracket D of the written statement, whereby the appellants claim to be in possession of this land. It is only for the first time in the cross-examination of DW1 that the respondent has admitted that the land is in possession of the respondent's respondent plaintiff. This cross-examination was in date
24/1/2005.
You said cross-examination on 24/1/2005.
2005.
Full stop. Therefore, comma. The notwithstanding. No, full stop. Plus, comma. The on 13/11/1996, the same was the date when the executive magistrate had attached the land pursuant to orders passed in case number 128 superscript M/96. Full stop. And in the second opinion of the court, the mere attachment of land does not establish or extinguish the right of any of the parties to a proceeding under section 145 CRPC. So therefore, it can be safely said that the cause of action for the suit arose on 29/11/1999 when the final order was passed by the Learned Executive Magistrate in case number 128 superscript M of 96, thereby declaring that the appellant was in possession of the suit land. Therefore, comma, based on title, which arises out of the valid sale deed, which is not under question, comma, the suit filed by the respondent on 24/1/2000 has been filed within 3 years from the date where the cause of action first arose. Stop merely because another date has been provided in the paragraph relating to cause of action does not give rise to a cause of action. It is true and settled that cause of action is a bundle of facts, and each fact must be examined in its own merit. And
In the claim, it is clearly stated that the cause of action of (13-11-1996) arose from the order of attachment passed by the Plenary Executive Magistrate. The same does not take away any right of the respondent plaintiff. But such right is found to have been extinguished on to the question by when order dated 29-11-1999 was passed. Full stop. Therefore, the first substantial question of law is answered by holding that the suit filed by the respondent plaintiff was not barred by limitation prescribed under Article 58 of the Schedule to the Limitation Act on the strength of pleaded cause of action by the respondent plaintiff. Next level. Coming to the substantial question of law number 2. Which is whether by not affording opportunity to prove or disprove the additional issue. The learned trial court have committed illegality. It is stated that that in the evidence on affidavit, the statement that though in paragraph 3 of the plaint, written statement, the appellants have taken a plea that the suit is bad for non-joinder of necessary parties, namely Achina, Achina, Achina Bibi, Samad, Samad, Samad Ali, and Anju Ara Begum. The just check it because I read I don't read so thoroughly. Both of you please check up. In the evidence on affidavit by this appellant, that plea is not taken. That plea is not taken in the evidence on affidavit filed by the appellant before the learned trial court. However, the plea is again renewed in the memo appeal as a ground of asserting the trial court order before in the first appellate court. Full stop. Therefore, as the plea of non-joinder of necessary parties was not framed when the issues were settled, and none of the parties were put to notice of the same. Which has even led the appellant defendant not to lead evidence on the non-joinder of necessary party. In the considered opinion of the court, as both sides had contested the case with the full knowledge about the non-impeding of several parties parties referred to in the written statement. The appellant cannot be said to be prejudiced by not affording any opportunity to prove or disprove the additional issues. There is another reason to take the said view. As per the provisions of Rule 9 of Order 1 of the CPC, is provided that no suit shall be dismissed by reason of misjoinder or non-joinder of parties. And the court may in every suit deal with the matter of controversy so far as regards the rights and interests of the parties actually before it. Pushpa. Just quote it, don't say it like this, quote it below. Let's start. Therefore, comma, the point is that the Anjuara Begum is merely a holder of agreement to sale and Anjuara Begum is Anjura Begum is the wife of the, who is the wife of the appellant, is merely holding she is having that agreement for sale. Anjura Begum, an agreement for sale. And it was taken by the, by her for specific performance of, for enforcing specific performance of contract. Therefore, comma, the title of the respondent having derived from the vendor who's made a pro forma respondent, comma, in the absence of any evidence by the appellant defendant, it cannot be said as to how Achina Bibi, Samad Ali and Anjuara Begum are necessary parties to the suit. Therefore, the second point of the second substantial question of law is answered by holding that the learned trial court did not commit any illegality in deciding the additional issue which was framed during the judgment writing. Resultant, comma. Next one. The further plea was taken that the suit and the appeal was without territorial jurisdiction. The decision of the Supreme Court of India in the case of Kiran Singh and others within bracket Supra was rendered prior to the amendment of the provisions of section 21 of the CPC, which came to be amended. 21 which came to be amended. 21(2), which came to be inserted by Act 104 of 1976 with effect from 1/2/1977, whereas the said judgment was rendered on 14/4/1954. Under the provisions of section 21 within bracket 2 of the CPC, no objection as to competence of a court with reference to the pecuniary limits of its jurisdiction shall be allowed by any appellate or divisional court unless such objection was taken in the court of first instance at the earliest possible opportunity, and, in all cases where issues are settled, at or before such settlement, and unless there has been a consequent failure of justice. Full stop. Therefore, full stop. Next one. Moreover, the erstwhile unified district of Kamrup was bifurcated into two administrative districts, being Kamrup Metropolitan and Kamrup Rural, in the year 2009. However, the judicial court in Kamrup Rural, headquartered with headquarters in Namingaon, was officially inaugurated on 19/2/2014. Which is prior to the passing of the judgment by the Learned Trial Court and the First Appellate Court. After. This is appeal of 2010.
Yes.
So you were before that?
Yes.
Or after?
After 2014.
Yes, it was inaugurated in 2014. Decrees are before that.
Before.
Before the bifurcation of the district. Stop. Therefore, with the district headquarters at Gauhati, when the undivided Kamrup district was there, it cannot be said that the retaining of the suit at the district headquarters at Gauhati would be bad for want of jurisdiction, as the district judge would be as the district judge would be the administrative court for the courts at Gauhati and even sub-divisional court at Nandia. Next one, therefore, though the issue of territorial jurisdiction was never raised in the suit, and no substantial question of law was framed, yet, as the learned counsel for the appellant has taken the plea, the same has been answered. Next one, resultantly, in view of the discussions about this appeal fails and the appeal stands dismissed. First of the registry shall drop the consequential decree. Next, the record of the courts of the General Trial Court in the First Circuit Court shall be returned. Right.